Item 1 for motion.
May please, Lord. This one pertains to compassionate appointment, Lord. Father of the petitioner died on the 26/8/2011, Lord. Only he, Lord. Yes, also one DLC, Lord, that was held on the 23/04/13, Lord.
What
Date of
happened?
13.
What
And
happened?
by the DLC, his claim was rejected, Lord. And before,
So now how you are challenging that DLC?
Lordship, what I'm submitting, Lordship, as per the settled proposition of law, Lordship, and the application for compassionate appointment, it has to be examined for 2 years, Lord. As per the Ochudran case, Lordship, as well as the office memorandum about 16/2000.
No, we understand everything. Now, what is your grievance? What is your prayer now?
Lordship, for
Hmm.
fresh consideration, Lordship.
How can it there be a fresh consideration for nothing? If the earlier one there is any illegality, we can interfere and send it back.
Without any reason, Lord, the rejection, Lord.
But this is after 10 years.
Lord, that is,
How can we reopen everything now?
Lordship, in that regard, Lordship, I have an
Hmm.
application, Lordship.
Mr. Gugoi, come with a better case. We'll give you the order. Rejected rightly or wrongly 10 years back without any reason. How can I ask them to now you reopen and re-examine it again?
Lordship, actually, in the year of 2021, Lord, the government decided to complete all the cases.
This
Lord.
complete, but yours is already completed. Your
Yes,
case is already completed in 2013.
Lordship.
Only the pending matters they will complete. I think this will be stretching it too far, Mr. Gogoi.
This is required to examine up to 2 years, Lordship. That is why I am different.
Understand. Understand? This will be stretching too far.
Lord,
Dismiss.
I will allow to withdraw, Lord.
Better you think about it. This is too far. 2013 dismissed, whatever it is.
It was communicated only on 2022, Lord.
Sorry.
Communicated only the year of 2022. That is why, Lord, delay was there, Lord, in approaching the honorable court, Lord. Lord, you will find
Why was it communicated? Page number?
page number 23, Lord.
Why was it communicated to you?
Lordship, there was several occasions approach, Lordship, from the petitioner, Lordship, to know the.
No.
status.
Why did the deputy commissioner communicate this one?
Lordship, he made an application under RTA.
RTI.
Lordship.
So he could have made the RTI Act was not in existence in 13.
Lordship,
RTI Act is of which year?
2005.
Same thing you could have done 10 years
Nothing
back.
was communicated, Lordship.
What
that is why-
happened, mister? Somebody, now the brokers are in the field. The report that we are getting, the brokers are in the field. Broker must have approached this one. Compassion, oh yes, 2013. Don't worry, I'll get an order for you.
He approached, Lordship, verbally, Lordship.
Understand. I think, what do you want? Withdraw. Mr. B.K. Gogoi, Land Council for Division 6, not to press with this writ petition. We have taken note of the background that the claim of the petitioner for compassionate appointment was rejected by a DLC of the year 2013. And no explanation is forthcoming as to why this writ petition is instituted in the year 2023, after a passage of more than 10 years. Writ petition closed.
Item 2.
This is all compassionate appointment.
And where is DLC?
Lordship, that is on 26/9/2016, Lordship.
Page number.
Page number 16G, Lord. And the type copy, Lordship, that is 16. To want of vacancy, Lord.
Yes, Mr. Pegu, what do you say?
It was rejected on the due to want of vacancy, my lord. And as per our affidavit, my lord, at block 15 was also considered, my lord, there was no other vacancy.
Was it considered? Bring the records. Bring the records of this department writing to the other departments, asking whether you have any vacancy, and reply given that there is no vacancy.
Sorry, my lord, this is in different case, my lord.
mixed up with some other
So
matter.
many compassionate cabinet cases. Office 30. Oh, yes. Page 30 of our affidavit, my lord.
Page?
30.
30.
Yes, as regard the establishment period of future reference, the assignment of active since there was no vacancy in any other department at that time.
They produced the records
My lord.
to something.
My lord.
In paragraph
5.
5 of the affidavit of the deputy commissioner, the assistant commissioner Nagaon, a statement is made that while considering the application of petitioner for compassionate appointment by the DLC of the year 2016, there was also an endeavor to find out as to whether any vacancy is available in any other department, and the endeavor resulted in the conclusion that there was no vacancy also in the other departments. The exercise that had been taken to arrive at such conclusion, the records thereof be produced before the court.
My lord.
List on next week.
Next week.
Item 3.
This is also for not, no,
Sure.
due to one of vacancies, Lordship.
2016.
Lordship.
Now, what is your stand, Mr. Pegu?
There was no vacancies at any other department, my lord.
Same stand.
Same standard.
But due to one of vacancy. only, sir. Not
No,
that
no.
one.
Did you make the endeavor to find out vacancies in other departments?
But,
Or is not done? Do it.
there is no vacancy in moreover tourism. My lord,
Mr. Gogoi,
20's headline.
Mr. Pegu,
my lord,
let Mr. Gogoi have at least one order.
my lord,
He come with 3 petitions.
my lord.
Heard Mr. B.K. Gogoi, land counsel for the petitioner, also had the father of the petitioner, Bichitra Patter, who was a grade 4 employee in the Kamgaon MP school, died in harness on 13/12/2016, and on his death, petitioner made an application for compassionate appointment, which was placed before the DLC of which district? Nagaon.
No government.
Nagaon district in its meeting of, where is it? Page number?
That's Lordship. We did 13/11/2017. It is
13/11/2017, page number.
page 30 of the affidavit in opposition.
The DLC. Where is Mandira Pator? Page number
Page number 38, Lord.
3.
38,
3.
serial number 15, Lord.
The DLC rejected the claim of the petitioner by providing that there was no adequate vacancy was available. The resolution of the DLC does not make it discernible that an endeavor was also made as required under clause 15 of the OM dated 1/6/2015 to explore the availability of vacancy in any other department. In view of the above, matter remanded back to the DLC of Nagaon district for a fresh consideration to make an endeavor to find out as to whether vacancies are available in any other department, and if available, to give a due consideration. Some bit of legal right violated we can,
My lord.
but if nothing is there, we also should not interfere.
Obliged.
Item 5.
Lordship, this is the compassionate. Lordship. It is the 2016 matters, Lordship. It is what happened, Lordship, he applied within time, Lordship, but there was no record of the visit.
Place it before the DLC, if already placed, inform me.
My lord.
BK Gogoi, সেইটো ক'ব লাগিব নে মাৰি দিব? Father Konok Gohai, grade 4, Poschim Simen Sapori ME School, Dhemaji, died in harness 39/2016, application 26/12/2016. The writ petition is instituted on a grievance that the application was not placed before the DLC concern. Again, it is.
I will until submission, Lordship. After filing the present writ petition, Lordship.
Uh,
After filing the present writ petition, Lordship, they will furnish a copy of the DLC, Lordship. In the held in the year of 2022. As per the DLC, Lordship, this case was placed on DLC, Lordship, that is held on.
Then you have
11
to withdraw this petition, file a fresh petition, challenge that order.
Lordship, due to want of vacancies, Lordship.
Understand? Then you have to challenge that order.
That is considered.
Otherwise, this will be a futile order for nothing. It is stated by Mr. B.K. Goyal and government that after filing a writ petition, the petitioner had been served with a copy of the copy of the resolution of DLC dated
11/2/2022.
11/2/2022, by which it is being informed that the claim of petitioners for compassion appointments to be rejected. In view of the above, the writ petition closed on being infructuous, but however, liberty granted to the petitioner to assail the resolution of DLC dated.
Item 6,
Yes, madam.
This matter is the compassionate appointment.
Who is the, was it placed before DLC?
My lord, it was, at the time of the death of his father, he was minor, my lord. Only after attaining majority.
No, was it placed before the DLC?
Your lordship may kindly see the last order, the deputy commissioner was asked to produce the record. His mother
That is
had
a court order. We want the.
his- earlier, his mother had applied and her case was
Chaudhary,
rejected.
we understand everything. Was the application of the present petitioner
Not placed,
placed,
not
not placed? Heard. Place it.
Not-
Khadim, follow Khadim.
Well, if not placed, but we have the records, my lord. I have not got to my lord.
You want some time.
I want some.
Mr.
This is the fourth date, my lord, for record.
His record is available.
Available. Next step will be.
Mr. Girin Pegul and additional second advocate for the deputy commission states that the records are available and some further time will be required to examine the same on the question as to whether the application of petitioner was placed before the DLC. List on.
Next.
Later,
5th December. Item 7,
Yes, Madam Talukdar.
May I please your lordship? Lordship, in this matter, the petitioner was appointed as an honorary subject teacher, lordship. In the year 2010, lordship, he has been working the subject logic and philosophy. And lordship, thereafter various resolutions has been adopted for converting the vacant third post of SMIS into logic and philosophy. Here
Issue notice.
issue.
Third MSA Talukdar and counter petitioner MS P Das for,
Secondary education.
no, for education department,
Yes, your lordship.
secondary or elementary?
Secondary.
For the secondary education department. Notice 6 weeks, extra copies 3 days, steps on respondent for registered post 3 days.
Much obliged.
item 8,
Keep the offense.
Compassionate.
This matter may be, assumed for the time being, man, passed over for the time being. I'm mentioning on behalf of S. Kanungo, madam.
That's just somebody else.
Yes.
item 10,
Then, yes,
My lord, this matter relates to compassionate appointment, my lord.
was it placed?
No, my lord.
This is.
If you are not placed, you place it. Same, eketa order di dibo. Ei agoto nisina. Who is the father when he died?
Father, my lord, Abdul Shahid, my lord.
Abdul Shahid, head
Abdul
teacher.
Shahid.
Abdul Shahid, head teacher, Sarapur ME School. Under the Bodorpur Elementary Education Block, died 23/2014. Application when did you submit your application?
2017 after.
4/9/2017. Not placed. If placed, inform.
11,
My lord, here also the case was not placed.
Hmm? আমি কি কম DLC হে কম please send the DLC to considering as per law. Just
Not placed, my lord.
not placed. Name of the father, school, date of death, date of application. Please give it. For information, father's name, where he worked, when he died, when application made.
12,
12, my lord. 12 also, my lord, same.
Her work seems to be very easy today.
13,
But give those names. Huh? If you don't give, we'll not sign the order.
Yes, sir.
Yes, sir.
Regarding compassionate appointment, my lord.
Same. Was it placed before DLC?
No, not clear.
Okay, order. Give those for information.
In sleep. taken.
Name, where he worked, when he died, when application made.
Okay.
14,
Yes, Mr. Islam.
The petitioners, they were appointed in their.
GPF number not allotted. That is a grievance.
They are covered under the old pension scheme and it is.
Why you are not giving the GPF number? Elementary Education Department.
I have received the instruction from the department, madam. Otherwise they are stipendary.
Sorry,
They are stipendary teacher, madam.
they may be stipendary. If they are stipendary, they are not entitled to GPF number.
No, other, they entitled, madam.
Sorry,
Entitled, madam.
entitled. Then give the number. That is the only grievance that I have not given the GPF number. Give it to
And
him.
it is covered the old pensions.
Sorry,
Other benefits under the old pension scheme.
They're basically relying on the judgment passed by this honorable court.
The covered by the common judgment by this court.
So whether it is covered or not, I was supposed to obtain the instruction.
no, no. I don't know. Last order that however, GPF had not been allotted to the petitioner, being stipendary teacher. So what is this judgment?
The common judgment that is covered by this case, your lordship.
Wherein it has been held that, madam, the
Page 341, your lordship, last para, your lordship. It is start from page 329. The similar. Your lordship. And finding of this code is, your lordship, page para 34, page 341. The lordship can also pass page 335, para 29, it is clearly
335.
para 29.
Are you sure?
Right.
335 is,
Page number, your lordship.
no, that is,
335, paragraph 29.
we understand that. 335 is amongst the first 10 or 15 pages of a judgment of 110 pages. So is the decision rendered in the first 15 pages? If the judgment gives a conclusion in the first 15 page, why will another 90 pages be written?
Judgment, yes, all the case number is not given.
No, I'm looking at page 335. But the judgment ends at page 409. So why a conclusion will be drawn
No, your.
in the first 15 pages and then the judge will write another 90 pages of the judgment?
Other categories of.
three categories of teachers.
There are
are
Achha,
dealt with.
different categories
Exactly,
in
madam.
one.
OBB, then, madam,
And
stipendary.
for this category, it is
Yes,
335.
yes.
It is start from your lordship 329.
That is possible.
Come on, everything, wait, sorry.
Where is the conclusion?
Conclusion page 341, your lordship.
341.
Paragraph 32.
Yes. Finding is clear. They will be entitled to pension
Yes, ma'am.
and be further entitled. This judgment remains, or you have gone in appeal?
No, it's remains, ma'am.
Remains. Then you give it to
Yes.
him. Heard Mr. S. Islam, learned counsel for the petitioners. How many petitioners?
Your lordship, in this case,
Five, madam.
5 petitions.
But also heard Mr. S. D. Khatonier, learned counsel for the elementary education department, Mr. Hilsalia for the finance department, and the R. Ahmed for. Which department you appear? For the Accountant General A&E Assam. All the petitioners herein were appointed as stipendiary teachers by various orders of the year 2001 and have taken a stand that although there was a condition in the order of appointment that they would have to undergo a junior basic training course and thereafter would be paid a regular scale of pay. But the circumstances were such that the respondent authorities had not facilitated the petitioners to undergo any such course. Accordingly, a claim is made that they are entitled to a regular pension and also entitled to the benefits of GPF. The said issue had been decided by this court in its judgment dated
31/3/2023.
dated 31
3/2023.
31/3/2022 in which writ petition?
23.
31/3/2023. Mr. Islam,
Okay.
if the questions were answered to the question we are asking, rather than trying to correct our answer order, in which writ petition?
The which is 6403/2021.
Are you sure?
And others there. It is the first case.
This is the difficulty.
Purnima Hore and others.
There must have been number of writ petitions disposed by a common judgment and 3 different issues are involved. In which issue the question of regular pension and GPF was decided? In which writ petition?
Is your lordship WBC number 5843/2020.
Are you sure?
Lordship, page 2329.
329.
The list is there.
In WPC
5843.
5843/2022 and other writ petitions, wherein in paragraph 34, it had been provided as extracted. As the entitlement of a stipendiary teacher for pension and GPF had already been decided, we accordingly follow the state proposition and direct the respondent authorities to provide the petitioners with their respective GPF numbers, which in fact is the relief sought for in the present writ petition. Accordingly, petition allowed. Requirement be done within a period of 1 month from the date of receipt of the certified copy of the order.
Obliged.
We are not deciding any other aspect in this writ petition other than what is provided above.
Item 15.
Yes.
Thank you, Lordship. My lord, the petitioner before your lordship is a student, my lord, and he has changed his name, my lord, from my lord Abdul Hussain Loskar to my lord Ayan Akhtar Loskar, my lord.
He has changed his name. How old is this person?
My lord, now he is my lord,
21 years. At what stage of his life he had changed the name?
my lord, recently, my lord, he has.
Recently, when he's 21 years.
Yes, my lord.
So now what kind of change you want?
My lord, actually, his original name is Abdul Hussain Loskar. Now he has changed.
Abdul Hussain Loskar, not Abdul.
Yes, my lord.
We know that.
Ayan Akhtar Loskar, my lord.
What do you want now?
He accordingly applied, my lord, to the Seva
Ah,
to change his name in
to
the
that change his name in the matriculation certificate.
certificate, etc.
And Seva rejected it.
Rejected.
Why?
He's decided to change his name by his own decision. On appeared in the HLC exam 2017, whereby my lord the school
Mr. Roy, is there a necessity a person cannot change his name by his own decision? And that decision has to be taken by somebody else. Nothing like that.
my lord
Anybody is free to change his name. Is there any legal impediment in changing it? Tell us that. If yes, we will examine the law.
yes, my lord, regarding the change of name, my lord, if there is any clerical error, my lord. If the
So that means the law of Seva states that no one can change his name in his life
within
unless there is clerical error by the Seva. Is that the law? Which provision? Let us see.
my
But Mr. Borguya,
My lord,
why should the Seva change your name?
because my lord,
No, I know you have changed to Akhtar from Afzal. That is very, very good of you. But why should the Seva change your name in their certificate? Because changing the name in the certificate will mean on the date when the certificate was issued, your name is Akhtar. But factually, on the day the certificate was issued, you were Afzal, you are not Akhtar. You became Akhtar only after 3 or 4 years later. So how can an existing fact on the day when certificate was issued can be changed because of a subsequent change of fact?
Yes.
I think,
in this regard, my lord, there is a judgment, recent judgment of the Supreme Court. my
let
lord.
us see,
I have not done, my lord, this.
find out which proposition you rely on. Let us see.
I have not, my lord,
Possibly there must be some authentic declaration by some authority that Akhtar and Afzal will be the same person. So wherever you go with a certificate containing the name Afzal, would be construed to be a certificate in the name of Akhtar. But the certificate
just
possibly cannot be changed. Just
the
let us
expected one, lord, I have seen.
see what the Supreme Court has provided. Let us see.
Just to give one, my lord. I have a main copy, I have also, my lord.
Find out the complete judgment. We'll have to look at it.
Yes.
Under what circumstance it was given, we have to examine it.
You also think this.
take care.
My learned friend also may check out on this judgment, my lord.
Mr. Borhuya, what is the first line of the judgment? What's in a name? So if it is the case of what's in a name, why do you want to change? What is there in a name? Whether you are Akhtar or Afzal, how does it matter?
It is detailed judgment, my lord. It is
I don't know.
guideline is given, my lord.
I'm just pointing out the first line of the Supreme Court.
Yes, ma'am.
Same point to my people.
Produce the complete judgment. Hmm.
Better may come up, my lord, day after tomorrow, my lord. In the meantime, my learned friend also gone through the judgment, my lord. I have given in the judgment.
Petitioner relies upon a judgment of the Honorable Supreme Court to substantiate his claim. The complete judgment may be produced.
Day after tomorrow, my lord.
We don't know.
Item 16.
Right. You take up whenever it is
29.
possible. Yes, Mr.
Diploma.
The case of Bodo teacher, my lord, Bodo assistant professor,
I think we have passed one order,
my lord,
same order.
same.
Give a copy of that earlier order. That's an interim order, I think, or
Yes.
final order.
Yes,
Interim.
interim.
Same interim order.
Notices. My lord.
Not yet finished. Issued done.
Item 17,
Officer has been issued.
No, we'll pass the same order as the other petitions. I think we should notice.
Yes.
Mhm.
Obliged.
Madam, give a copy of that earlier order so that we can pass the same order.
Yeah, please. This matter is regarding transfer of the petition. my lord.
Transfer.
My lord, she submitted online application for his transfer. my
Just a
lord,
minute,
from
mandamus
Hailakandi district.
directing the respondent by the respondent 2 with 3 to do.
He already completed 10 years of service, my lord. He is entitled as per rule. my lord.
She wants a consideration of her application. Consider pass your order. If you reject, give reason, reject. If you allow, we allow it. That's the only grievance.
Yes.
That
One application is pending.
one exercise, she wants you to look at the application. Heard Mr. S.B. Law School and Council
HL.
petition. Oh, yes,
HL Ashkan.
you are HA, not SB. HA Law School and Council for the petitioner. Mr. P. Nayak for the
I'm appearing for respondent number 2 and 5.
for the authorities SSA, Madam MSS Chutia for Department of School Education, Government of Assam. The petitioner is an assistant teacher bearing employee code into Sailago, page 4 say bracket comma SSA comma contractual at Dalkipar LP School under the Katlichera Education Block in the Hailakandi district, having been appointed by an order dated 19/5/2012. In course of her employment, she got married on 8/10/2015 and her your marital home is in Kahilipara or matrimonial home is in Kahilipara?
Marital.
After marriage, she is residing in her in-laws' place at Kahilipara Hillside Colony at Guwahati. In the circumstance, the petitioner made an online application number, para 4 application number, enter something, on 10/8/2022, seeking a transfer from her present place of posting to any suitable post under the Guwahati Education Block in the Kamrup Metro District. The limited grievance raised is that said application had not been given its consideration. In view of the limited grievance made, who will do it?
Mission director.
The mission director SSA is directed to consider the application of petitioner for transfer and pass a reasoned order thereon as per law and as per applicability. By requiring the mission director to consider application, we clarify that it is not a direction from the court to allow the prayer of the petitioner. And on the other hand, it is a requirement of the mission director to make a due application of mind and pass any reasoned order on the same as may be applicable under the law. Requirement of passing the order be done within a period of
1 month.
1 month from the date of receipt of the certified copy of the order.
Most of it.
Obliged.
18,
Yes,
Here is my lord, the non-holding of election for president of the school management committee.
President, School Managing
Is-
Committee. Okay.
My lord, kindly see page 23, the relevance of the minutes of the general meeting. I have been selected as a member. Thereafter,
I
I,
read direct to hold the election for the post of President School. Election.
yes, because 3 candidates' names were proposed in the general meeting. My lord, therefore, they choose to elect, they fix a date for election of the president. My lord. My lord, after,
Election under which provision of law?
my lord, kindly see the notification, my lord, page 40,
Page 1440.
140. my lord, clause 13, 1, subclause 2, my lord, 2,
Just a minute, except power convert 21 of the right, please to reconsider this one.
B, my lord.
Sorry?
President and vice president shall be selected oblique elected.
Now, who will hold this election? Election Commission.
No, my lord, the
Again, ballot box, voters list. My name is included, my name is not included. And litigation goes on and on for a few more years.
so 3 names were proposed, my lord, therefore the returning officer is the headmaster.
Yes, who appears for the department? Okay. What kind of election will you hold? Hmm. And if for every school president you have to hold an election now, the academic atmosphere will be disturbed. And the presidents will be campaigning for the next 1 month, that give me the vote, other one say, give me the vote and all. Hmm. Why is the necessity of all this? Under the RT Act, you have a president. You have a notification how to put in place a president, do it.
But my lord, page 39, the order of the additional deputy commissioner. Now my daughter's admission is going to be cancelled. my lord.
No, your daughter admission will take care of your daughter separately. But regarding the president and election, we are having some, I don't know, we'll have to look into that as well. Mhm. Anyway, our countries, we have no shortfall of elections. Almost every year, around the year, some election or other is going on. Why add one more election to all this? Yes, Mr. Khatanier, what is this election?
In case of guardian, my lord,
No, president and vice president, that is a Right to Information
be
Act, I think
selected.
is relying on. Shall be selected stroke elected. RT is a central act.
yes, my lord. That is the. Normally, earlier it was a selection, my lord.
Why do you need democracy everywhere? Hmm. See, tomorrow if my neighborhood, those Kinara shops, they also demand a democracy. To which shop I will go and purchase my grocery? Let there be an election now. Is there any requirement? You find out the most suitable candidate, appoint him as the president. So therefore the word select is there. Why have you failed in that endeavor to select? To go to the next stage of going for a election now. Constitution does not seek for democracy
Yes, I understand, my lord. That I
at
understand.
every level. And now who will vote in this election?
Obviously, my lord, the
Parents.
parents
Parents.
Parents or guardians, my lord.
So you'll prepare a voters list.
Their information, my lord, I don't have.
And after preparing the voters list, you'll call for objection. If wrong name had been included and right name had been,
Election, I think that election is, doesn't matter that, my lord, we have to.
no, election is election. That's what he is claiming. I want election now. Give it a direction to hold a election.
Maybe raising the hand also, that can be done, my lord.
Now, who will raise the hands? Tomorrow will someone say, one of the raised hands, he is not an eligible person to raise hands. Again, come back to the court, steady everything.
So sometimes it is difficult because there are more than 2 or 3 candidates, my lord, for the post of president or vice president. That is
So
why-
you devise a better method to find out.
Let me have the instruction, my lord, why this procedure has been.
If there are so many people, why don't you call for applications? All of you give your application with your credential, we'll hold one interview, we'll hold one written test. And out of that, the best person will be selected.
I don't know, fix it on next week, my lord. I'm opting certain whether.
Difficulty is if I allow this petition with a direction
I
to hold election, from henceforth the law will be that for
Everywhere.
thousands of schools in Assam, every school will have one election every 3 years. Hmm.
I don't know, fix it on next week, my lord.
Adjourn the
Then,
prayer.
my lord, that my name, daughter's name may not be deleted. In the 6 or 6.
Your daughter is a student
Yes.
and they want to delete you as a student. Why? How is it related with the election of the president?
Because the moment when I submitted my nomination paper, the headmaster raised a question, then now by hacking the password, my name has been entered in the portal, my lord.
Hacking.
Hacking, my lord. And therefore the additional.
Hacking is a offense under the Information
It was right,
Technology Act.
Yes, my lord. Therefore, the additional division, the headmaster has not filed the loss, FIR till date, my lord, but disputing that.
Mr. S.K. Roy, Learned Counsel for the petitioner, has raised an assertion that the writ petitioner Sasima Begum,
Yeah.
Safia, if she wants to become a president,
So,
that the writ
Sabina,
Sabina Begum intends to become the president of the which school?
Summarily,
Samoroli, Amodia
Amodia.
LP School.
Of Samor,
Samoroli,
Samoroli
Amodia.
Armodia LP School. And in order to be the president, there is a requirement that the person should also be a guardian of one of the students of the school. The daughter of the petitioner, namely Sabia Muskan Dilhaz, aged about 9 years, is a student of the said school. But under an unexplained circumstance, the name of the daughter of the petitioner, Sabia Muskan Dilhaz, disappears from the list of students of the school. The headmaster takes a stand that the website of the school was hacked, and as a result of that, the name of Sabia Muskan Dilhaz to delete it. The director to take necessary action under the, what is that called? Cyber, under the law of cybercrime, and refer the matter for investigation as to under what circumstance the website that was hacked and who had hacked, and take necessary action, and thereafter file report before the court. Till the next returnable date, the student shall not be disturbed from being the student of the school concerned. List also and so.
Item 19,
See, to what dirty politics comes in when you go for election. That's why you are apprehensive of accepting this information. It would see that to extent they have gone, some rival candidate must have hacked the website delete the name of the daughter of this person to make the person diseligible to become the president. Hey, what is going on? Why don't you stop all this president and all? Start inviting applications. Start inviting, make a formal recruitment.
And opening stuff.
There's no other way out. Otherwise,
Yes.
this is one step. Tomorrow it will go even further down.
Yes, ma'am.
Next day you'll find somebody killed by one person or the other also. Why? President of a school managing committee, some vague LP school in some corner somewhere.
Complete.
May it please your lordship.
Yes.
Lordship, the petitioner herein, my lord, is working as contractual teacher who is claiming appointment under a regular sanctioned post of assistant teacher. Now, the petitioner case in brief is that. my lord,
You know, you are a contractual teacher
Yes,
and you want to be appointed as a regular teacher.
Yes.
Under which law?
my lord. Annexure, my lord,
Mhm.
annexure, my lord. Page 31, 32. my lord.
Is there any rule or scheme for that purpose?
No, my lord.
Then,
Because, my lord. My lord, petitioner fulfill all the norms, my lord, laid down by the.
there will be thousands of people who will satisfy all the norms for a teacher.
My lord, he possesses all the necessary qualifications.
That's why I say there will be thousands of similar people who will be possessing this qualification.
But in this case.
So why should the petitioner be given a regular government employment?
Yes, but in this case, my lord, I have to point out one more thing.
Yes, please.
Annexure, my lord. 31, my lord. Annexure 31. This is the notice given by the headmaster, my lord. Others are Rashtra Bhasa.
General information that Ramnath Thakur, assistant teacher of Adarsh,
After the expiry of this teacher, my lord, the post of the assistant teacher in this school is laying vacant.
no, let them advertise the post, you also appear. And by virtue of being a contractual teacher, if you are entitled to any kind of weightage for experience, etc., that will be given to you.
In that case, my lord, my representation.
Sorry,
My representation may be disposed of.
what is your representation? What have you claimed in your representation? To be regularized or to be allowed to participate?
In that particular.
So that claim itself, we find it doesn't have the sanction of law. Why should he direct that representation to be considered? Long time back, I gave one example. Today you file a representation, deputy commissioner, I want to murder X. Please allow me and pass an order. Okay. Then you come to the court and say, issue a direction to dispose of my representation. Will that order be passed?
My lord, because of this.
In other words, when we pass a order to dispose of direction, we are satisfied with the legal right claim there. Here we are not satisfied. So why should we direct that representation to be considered? We can provide you if you want to participate. You will participate. They'll give you necessary weightage for your experience, for your all
That may be
that you are entitled.
That may be.
Will it be sufficient for you? For your client, I mean.
That may be done.
Your client will go after you. What will you do with my case?
He is working against a contractual post, man. And the students of this school, my lord.
Understand? But that,
Yes, you must-
under the law, it cannot be allowed. Check up all the judgments of the Supreme Court. This cannot be allowed.
Then whatever you.
You ask your client, or else I'll put Mr. Upaithai at a difficult situation. Your client will come and go after you. You consult with your client, come back. We'll post it next week. The petitioner, who is a contractual teacher, claims to be regularly appointed in a vacant post in the school which had arisen on the death of one of the existing regular teachers. Mr. White seeks for an adjournment to produce any relevant proposition of law whereby an existing casual or contractual teacher can be directed to be given a regular appointment upon a vacancy having arisen in the school on the death of an existing teacher. The petitioner to also obtain the information as to whether to learn counsel to also obtain the instruction from the petitioner as to whether he'd be satisfied with a direction that in the event of any regular recruitment taking place against such post, he'll be allowed to participate with necessary weightage, etc., for his earlier experience as a contractual teacher. Response also.
Item 20,
Yes, Madam Das.
But to join as a technical assistant, my lord. On page number 23, my lord.
What is it? Directing us to accommodate the petitioner to the post of planning statistical officer.
This presently discharging his duties in Nagaon, my lord.
What kind of a prayer is this? To accommodate the petitioner to the post of planning statistical officer from the date of his promotion as per the provision of right of person with disability. How do you link up your promotion, your accommodation and disability?
His son is 50% disabled child. And
Okay, son is 50% disabled.
and his wife also undergone a major surgery, madam, before 2 months.
Okay.
And his daughter also.
No, I understand the family is in distress. Now,
That's why
now
he
what
filed-
legal right flows from that?
That's why he submitted representation by showing the reason, my lord. After that, they are allowing him by verbally directed him to discharge his duty in Nagaon, my lord. Then
Achha, he is originally posted in some other place.
my
Which place? Golaghat. So now you are allowed to discharge duty in Nagaon. Now, what kind of prayer you have now before the court?
My lord, he is
What
deciding-
relief you are seeking for
My lord, I may be absorbed in the vacant post because I.
at Nagaon?
My lord.
You have filed a representation. This is
And-
under which department?
My lord, in education department.
And the post you are holding?
I was planning and statistical officer.
Planning and in the education department. These are district-wise posts. Golaghat will have one post, Nagaon will have another post.
Second post now. Because
Nagaon is vacant.
it's available.
Yes, Mr. Sharma, why don't you accommodate this person? She's having a lot, I think it's a man or he's having a lot of difficulty. Son disabled, wife something, another daughter something.
The direction having even to dispose of.
And that post is vacant. Unless you have a reason that administratively this man is most unsuitable for that post, we see no reason why you can't place this man there. And what is the provision of the Disability Act? Let us take a look at that. You're relying on the Person with Disability Act. Which provision? Hmm.
Act is a statutory mandate for recognizing the principle of reasonable accommodation for a disabled member of society. This obligation has.
Which section? What are you reading? Which page?
Page number 6.
Page number 6. 6.
No.
6 must be your averment. Where is the law? This is your averment, your submission. Is there any such provision in the Disability Act? এখন তো 95 2016 এখন আছে বোধ হয় নাই এই রুলস কি দিছে রিপিল বাই দি অ্যাক্ট অফ রিপিল অ্যাক্ট it's 95 এখন ডাঙৰ হ'বতো এই Madam Das, please wait for some time. We'll take a little later.
21,
Wait, please, my lords. Lords, in this matter, Mr. B. Chaudhary appears. Lord, today he's out of station. Yes,
Adjournment.
yes, my lord. For a week.
Also লিখিব adjourned.
I'm obliged.
22,
Wait, please, your lordship. Lord, petitioner before your lordship, my lord, he is working as a my lord junior assistant in the library.
Sorry, junior assistant in
Junior assistant library.
junior assistant bracket library.
Library means my lord, he is the posted in
Ah, ah.
library.
Ah.
There, that is your lordship will find it page, my lord, 27.
Impugned letter and GB rule declaring the same as void.
No, that I will come to that, my lord. before
Ah.
that. Junior assistant library, I was working in library, page 27, my lord. That was in 2007.
Hmm.
Initially, I was appointed as appointed in 2001 as a gate 4, my lord. Then I was promoted as a gate 3. Qualification after 7 years, there is a qualification. I was promoted in 2007, and 2007, my lord, I was appointed as a junior assistant library. Then I was, my lord, shifted to my lord general branch,
Not library.
not library again, general branch.
Huh.
So I'm working in general branch, but shifted to general branch, page 20.
Hmm.
Thereafter, my lord, so I am eligible to get promotion to the post of my lord, senior assistant,
In the stream of the general branch.
general branch,
Huh.
so senior assistant.
Huh.
So accordingly, my lord, although my dues, my lord, but I was, my lord, made in charge of the, my lord, senior assistant in that college, particular college. So
Huh.
I am holding that post, my lord.
Huh.
So that thereafter, my lord, I apply for leave. 15-day leave because of my wife email. I leave for, I come to the Guwahati. And again, I leave, availing the leave, I join in my post, and I join my post, and then my lord, principal, my lord, referred back to my original post to the
Library.
library assistant. I am no grievance on that, yes. But now, my lord, that decision has been taken by the principal of the college with a GB meeting, but there is no such GB meeting as such, my lord. GB principal has said, my lord. And my lord, now my lord, charge has been handed to
See, principal takes a decision on the basis of a GB resolution,
exactly.
and there is no GB resolution.
Then
Then this is a fraud committed by the
My
principal.
lord, your lordship, kindly see page 45.
40,
Page 45.
45.
Page 45. That Siddhartha Shankar Nath is the principal, my lord, he is actually suspended. again
Page
came-
45.
Page
Sorry.
40.
Biswajit Jadhav,
Yes.
you a petitioner.
Petitioner is Biswajit Jadhav, library assistant, to resume his duty as a library assistant. As per GB resolution number 7, dated 20.
And according to you, there is no resolution 7 of the GB.
That, my lord, page 22 is clarified because that, my lord, sorry.
Page
Yes, page 22, my lord. Page 46, next page, my lord.
46.
With reference to the site, has your lordship got page 46, my lord.
subject cited reference said above, it is stated that neither had you asked me for any consent or nor did I give any consent for holding meeting of the governing body for Kachar College.
So now, which is your impugn order?
No, impugn order, that is, my lord, page 45,
45.
page 45.
So heard Mr. T.J. Mohanto and Seneca, also heard Mr. E.R. Tobila, Land Counsel for the respondents in the Higher Education Department. Issue notice returnable. Do you have tomorrow fixed date at the video soon? Returnable on so and so. The petitioner Vishwajit Yadav is stated to have been appointed as a grade. As a
Initially,
as a grade 4 employee,
employee and
grade 3 employee, I think. Grade 3 employee in the Kachar College and had been promoted in his stream of grade 3 as per entitlement. In between, he was also designated as library assistant. Thereafter, he was holding the in charge senior assistant of the college, and he had gone on leave for about 15 days. When he returns back, he served the communication dated 8/9/2023 of the principal of Kachar College, whereby he is asked to resume his duty as library assistant. Significantly, the communication states that the requirement of the petitioner to serve as library assistant is as per the GB resolution number 7 dated 28/8/2023. But the president of the GB of the college, by his communication dated 29/8/2023, asked the principal as to why they informs the principal that the president of the governing body had neither called for nor had given consent of holding any meeting of the governing body on 28/8/2023. And further, that it appears that the principal had surreptitiously held a meeting of the governing body in contravention of Rule 12(2) of the Assam Provincialized Colleges and Assam Non-Government College Management Rules 2001. In view of the communication of the president of the governing body dated 29/8/2023, the communication dated 8/9/2023 shall remain stayed until further orders, meaning thereby that the petitioner would be allowed to resume his duty in the same post which he was holding prior to the petitioner going on a leave. The director of higher education Assam to make an inquiry under what circumstance the principal of the college had issued the communication dated 8/9/2023 and thereafter submit a report before the court. If the petitioner, if the conduct of the principal appears to be any kind of a misconduct in the view of the director, the director to inform the court as to what appropriate steps are required to be taken. List on so and so. The principal of the college be served dusty by the petitioner as well as through registered post.
My lord, also my lord, private respondent, because now he has been given a search to a my lord.
Private respondent, the respondent and registered post. We are not concerned with the private respondent. At his behest, he must have done it.
Yes, my lord. He is not in.
4 weeks, no? Anything after 4 weeks?
No. 2 weeks fixed date.
6 December.
No, we are little perturbed. Some of these principals are.
That same principal, that same Siddhartha.
Which one?
That principal.
That means?
This principal also, my lord, suspended. Now he's joined and immediately he's doing this.
Earlier he was suspended.
Suspended, my lord, probably.
So, suspended for what reason?
Some that is this type of activity. The Siddhartha Shankar.
I don't know. Next, Azikiman Tariq. Sorry, on 6th. Because some people are, some people, they spoil the atmospheric, academic atmosphere, and they are not fit to be principal.
Yes, sir. Good conduct the inquiry.
Principal should be a respectable person. Anybody seeing a principal, that devotion should come in his mind.
Automatic.
Automatically. This is the status of a principal in our society.
Okay.
And if he indulges in this kind of activities, fundamentally he must be unfit. Take a look at it.
Oblige that.
24,
24 years, Mr. Loskor,
My lord, this is a compassionate appointment, my lord.
placed before DFC.
No,
Very same order. Name of the father, when he died, date of the application.
particulars.
oblige.
25,
Right, please, your lordship. Lordship petitioner before your lordship is the social science teacher, my lord. Page 36 is the recommendation. Page 36, my lord.
36.
My lord. Fazal Ali is the petitioner. The district executive committee recommendation. Page 36.
Okay, district scrutiny committee recommends him as a social science
Social
teacher.
science teacher, my lord. And Alia Khatun is language.
And Ali
Alia
Khatun is language. Now,
Then, my lord, Motleb Ali, who is not eligible, Motleb Ali Mundal, headmaster language, my lord. Now, my lord, page 41.
where is Mr. Kaushik and Chisti gone today?
In legs in Arago.
No, I don't. Can we have him for a minute? Just for.
Page 41. Page 41, serial 540. This is the provincialization website selection. 540, Motleb Mondal. That Motleb Ali Mondal, headmaster, has been provincialized, although he was not.
As what teacher?
Yes, language.
Where is it written, language?
MLS page 40, language page 36.
No, I know. Where it is written that Motleb has been provincialized as a language. Okay, subject for
In
language.
website list, my lord,
Okay, Motleb becomes language and
language, and Alea also language,
Alia also language.
542.
Huh.
But Motleb Ali, kindly lordship, see the writing, all are capital letter. His name is small letter, my lord.
Whose
Even
name?
is not full. Motleb Ali Mondal, recommendation page 36 is
But the serial number is maintained.
maintained, my lord, although he was not recommended, but he was provincialized. Yes, language. So two language teachers have been provincialized, and during the process of provincialization.
Third, Mr. Amar Khandakar, petitioner, Mr. Ganesh Pegu for Elementary Education Department, Mr. Girin Pegu for Deputy Commissioner.
Yes.
Deputy Commissioner, so and so. For the purpose of notice 6 weeks, extra copies 3 days. For the purpose of provincialization under the Act of 2017, the District Scrutiny Committee, as per Annexure 5, page 36, had recommended Fazal Ali, the writ petitioner, as a teacher of social science for the Torangapur Koran Jyoti ME Madrasa, and Alaya Khatun as language teacher. And on the other hand, Motleb Ali Mondal, who is the headmaster, was not recommended, although he is shown to be a teacher of language. But when the provincialization order was issued, as per serial 540, Motleb Mondal had been provincialized as a language teacher and Alaya Khatun also as a language teacher. But in the process, the social science teacher, namely Fazal Ali, had been left out. Section 3111 of the Act of 2017 provides for provincialization of 3 teachers in a ME school, one being science and mathematics, another being social science, and the other being language. And there is no provision under the law to provincialize 2 language teachers. As Motley Ali Mandal was not recommended by the District Scrutiny Committee for provincial. We accordingly stayed the provincialization of the respondent Motley Ali Mandal until further orders. Yesterday, we were telling you the nuisance these headmasters create.
Yeah.
Remember?
Yeah.
Headmaster is not entitled and the kind of manipulation he does. Here is a case, come to page 36. 36. Please. Please. Come. We'll hear you a little later.
Format for
Scrutiny committee recommendation.
Yes, yes.
Fazal Ali, social science, Alaya Khatun, language, Motleb rejected.
Yes.
Headmaster shown as language.
Yes.
Provincialization, Motleb. Alaya out. This is what we told you yesterday. Means all our experience shows that there is some inherent defect
Yes.
in the entire thing.
Motion.
Here we are passing an interim on a different matter. I just call you to
Yes, yes.
show it to you
Yes, yes.
that why this problem is happening.
Yes.
Okay, you can go for your other duties. Just take note of
Yes,
this
I will
one
take
also.
Yes.
My lord, but Motley Ali Mandal, he has retired. Ali also died before provincialization. Two language teacher. He retired, Motley Ali Mandal retired on 7/2/22. And
Retired on
7th of February 2022.
22. And what is the date of this order of provincialization?
Provincialization, my lord.
21.
4/4/20.
So we are staying it.
And my lord, Alia Khatun.
It is stated that in the meantime, Motlab Ali Mandal had retired from service and Alaya Khatun had also died.
Died on 15/11/2019.
As the writ petitioner had been incorrectly left out from being considered for provincialization as indicated above, the pendency of the writ petition shall not be a bar on the part of the respondent authorities in the elementary education department to consider the claim of the petitioner for provincialization as per the recommendation of the District Scrutiny Committee, which is available as Annexure 5, page 36 to the writ petition, list after 6 weeks.
26.
I am always. Capital also time. I am. Regarding compulsion appointment, madam.
Regarding,
Compulsion appointment.
was it placed before DLC? Not placed. Same one. Name of the father, date of his death, deputy application, which school he studied, he is served.
Developed.
Order stay vacating item 28.
Hello, as per court's order, my lord, district commissioner. has
Last
filed-
order 910, deputy commissioner states affidavit filed in course of the day. It is filed.
Affidavit filed, but we have not received copy. I have checked, that is filed. I don't
Mr.
know.
Pegu? No, he says that he did not receive, is not served with a copy.
I'm the petitioner.
Your name, Ms.
M. Ali.
M.
M.
Ali, for whom do you appear?
My lord.
For whom do you appear?
Is for a petition.
I'm for the petition.
Petitioner, and you are for?
I'm
Acha, for the IA applicant.
I-
Mr. M. Ali Lankan, petitioner states that the affidavit filed by the deputy commissioner had not been served on the petitioner. Necessary copies may be served, list again also.
Problem.
May take it, take.
29 for admission.
That's Caesar.
Yes, sir. The last occasion that is, lordship is.
Last occasion adjourned on the inconvenience of Mr. Sahu.
So-
Before that, we required you to produce any relevant proposition of
Yes.
law.
I have brought the provisions, settled citation, settled by the Supreme Court as well as the various high courts, and that will be
help your lordship regarding
I think we'll have to hear this matter.
yes, sir.
It'll take some time.
Lordship, in this case, what happened? Rubber were seized.
No, what I understood, goods were seized, then confiscated.
Yes, sir.
Confiscated or only seized? Seized, I think, not
Seized and
confiscated.
Actually, that was set aside by the.
Seizure was set aside.
Yes,
Before that setting aside, the goods were sold in auction.
yes, okay.
According to him, auction price value is much less than the actual value of the
Yes.
goods.
This is.
So he is in a writ petition claiming the actual value of the goods. To why it is not maintainable?
Lordship, what happened when auction was published, lordship, then notice was given to him, and before auction we obtained, we completed all the formalities. What we have obtained, the approval of valuation confiscated seized from the value order.
Means you have conducted the auction by following all the procedures, and that we understand.
They have not been challenged before this one.
Hmm.
Now their contention is that since the CJ value was more and it was auction and less price, so they are entitled to that value initially it was conducted by the authority.
At a later stage, can you do it? This judgment
Yes.
of,
Price is to-
of Calcutta High Court.
Calcutta Supreme Court also there, 99 ELT.
Let us see the Supreme Court, then going by
Also
the
there.
Calcutta High Court.
I have submitted two citations.
Give the Supreme Court judgment.
So actually price of the goods to be refunded at the time of seizure, what the price is, whether it is higher or lower, that doesn't matter. The price determined at the time of seizure, that is to be refundable. That is the
Sorry, price?
determined at the time of seizure.
Price determined at the time of seizure. Who determines that price?
Customs authority. That is at the time of lordship in seizure list, amount was mentioned.
Uh,
And the lordship
that amount was mentioned after determination or without determination?
at the time of seizure only,
It's
On the
after
basis of-
after
on
determination.
the basis of market value.
On the basis of market value, the seizing authority had made a determination.
Lordship, actually, it will be wrong to say that determination was made. On the basis of market value, because the value was put in the seizure method.
And that's a determination. He determines that
yes.
this is the market value.
Yes, because there is no such a mechanism. Only on the basis of market value, the. value
Mr. KL, suppose 1 kg of atta, what is the value? Today I'll have to know. I have to write in a document.
Lordship,
I'll go to the market and check it up
yes, Lordship,
to the nearby shop. What is the value? He says it is 10 rupees. I'll put it 10. That means I have determined it.
and Lordship, what happened?
I have determined it.
Yeah.
On the other hand, I had not made the endeavor to find out what is the market value. On a random basis, I put one figure. I had not determined it. But here is a case, you say that I have put in the market value, so you have determined.
No, Lordship, what happened? The goods were seized. Then it was challenged. Then they approached this honorable court. Lordship, please to come to page 134. After disposal.
No, let us read this proposition first. Which paragraph you are relying?
I know, actually, page number 16.
Page number 6.
With judgment in Supreme Court,
No, Supreme Court, which paragraph?
paragraph is paragraph 9.
9.
In the middle of the last, middle of
Just a
the.
minute. What kind of a This thing is RK Jain GST extra.
excise lot, this is the.
No, the font and line is so small, we're finding it difficult to read.
Hello, so yes.
Don't you have a better copy? SEC online you don't have.
Yes, that is a thing.
How can you read this one? The firstly font is small
There's another-
and the difference between two lines is less than 1 millimeter.
This reported by AIR. The font size is larger.
Same matter reported by AI,
AIR,
para 9.
para 9.
Madam Ghosh, just a minute, we called you for a particular purpose. Huh? Just after this matter, no, but there is no determination in this judgment that in the event the goods are subsequently sold in auction, what will happen?
Yes, it is not there.
There the goods were not sold in auction. Goods were with them. So Supreme Court says the SSC is entitled to refund of the goods
Yes,
minus the duty, whatever the value.
yes.
So therefore, and there the value of the goods is 33 lakhs, which was shown in the import document. So that is written. Now, here is a case, the value of the good had been subsequently redetermined by virtue of the auction.
Yes, subsequent.
Auction is a free play method of determining the value of any goods. So when the auction had determined what the amount, you are definitely entitled to refund of that amount. How can you now claim that my value of my goods is something much more than the auction value?
Actually.
Now, who will determine that?
Actually, at the time of seizure of the goods, the customs authority determines the value.
Where is the determination?
Yes,
Under
page
which law
number
they determine? Let us
Page
see.
number 16.
Let us see.
Petition, annexure A, page
No,
number
no,
16.
under which law they determine?
They have at the customs section.
Let us see the
110.
Customs Act, page number
16, 16.
16.
The seizure, at the time of seizure, they have determined the value.
Seized under section 10, inventory of seized goods, estimated value,
Yes.
not a determined value.
They have determined by this way. And
There is a
subsequently that
difference
was-
between an estimated value and a determined value. If Mr. KL has to find the value of the coat you are wearing, he may make an estimated value, it will cost around 1,000. Write it down. If he has to determine it, he'll have to go to the shop from where you purchased, the tailor to whom you've gone, add up the price and then say it is 2,500. That is
Yes.
difference between
This matter-
estimated and determined.
This matter has been decided by the Honorable Calcutta High Court.
So,
And I have submitted the
by the which court?
Calcutta High Court, 2014. Calcutta.
See, if the reasoning is good, we'll accept,
Yes,
otherwise,
fine. That has been.
otherwise we may
To
not.
see the certificate issued by the competent surveyor. I place the record.
But,
Calcutta High Court.
instead of going to Calcutta, why the valuation by the surveyor? Because the goods are seized. Admittedly, the seizing officer makes an estimation, and it must be this much, without determination. Later, goods were subjected to an auction. Before auction, they get it determined by a valuer.
That is not been done by.
Sorry,
Department. Yes, that valuation has not been done by the.
by no, by the valuer.
Yeah,
He's an
registered-
official valuer.
Registered valuer.
No.
He's a registered official valuer.
Yes, and look, thereafter auction notice. was
Registered
issued.
official valuer, their value has their own meaning.
That will- So actually, whatever auction, that is their internal matter, not relating to the claimant.
No.
Actually.
Mr. Sahu, we are having difficulty in accepting what you.
Calcutta
And
High
anyway,
Court-
what does, so the Calcutta High Court says?
Calcutta High Court has decided,
Which paragraph?
2014 ELT,
No, the name of the party, Ehsan Waris.
Essence Waris, Essence Waris. This is a division bench.
Maybe division. No, Ehsan Waris is not
Yes.
division, it is
No,
single
single
bench.
bench.
Ah.
Essence Waris.
Which
is
paragraph?
Paragraph is 9.
9.
Since the sales will already been affected, that is, it is to be laid.
Somebody's mobile phone is speaking something. Please put it aside. Para 9 says, if any confiscation or seizure is subject to any appeal or before any tribunal or court, they shall not be auctioned or disposed without written permission. This is only says. Here you did not do that.
But here.
You could have done it, you did not do. Where is that? We directed to refund 26. That's a facts of that case.
Yes, in this case, they have confiscated.
No, I think
And I
they,
succeeded.
I think they follow that paragraph just now we read of Supreme Court.
Yes, right.
But this paragraph, we find it not applicable in this case. Maybe in the Calcutta it was applicable, not before us.
And another case is Calcutta in 2017 ELT, that is of the same set of.
Mr. Sahu,
Right.
Calcutta follows that Supreme Court, that particular paragraph and passes its order, you refund so much of amount. Very well. We find the relevant paragraph of the Supreme Court is not applicable in this case. Calcutta High Court found it applicable, they have passed their order. We find the Supreme Court paragraph not applicable. So why should we now follow Calcutta now again? If you're not following the Supreme Court, find it different.
Actually, that is.
The Calcutta following Supreme Court is not binding on us anymore.
Actually,
Not persuasive also.
My humble submission in this case, my lord, the claimant should not be in the loser condition, loser side. Whatever they
Never.
have confusion, they should get back their.
Never. You take back your auction money. We are ready to pay that. We are not saying that you will not get
Actually, that is
anything.
1,50,000, that price is more
Then
than
you
5
challenge,
lakhs.
then you challenge the auction.
Yes, Lord,
Then you challenge the auction that it was a fraudulent auction.
we have challenged, in this case, we have challenged this bid. I mean, this is the second bid. We have challenged this auction. this
Mr.
auction
Sahu,
is
maybe
not-
any number of writ petition, but your remedy will lie in challenging the auction that the auctioning of the good at a particular price was either fraudulent or illegal or whatever it is. There you will be establishing your right that the value of the goods is something different and not the auction value. Once you get that determination, you come back to us, we'll ask you to direct them to refund you that amount. But before that, under what provision of law, under what circumstance, we draw a presumption that the value of the goods is not the value that it was auctioned at, but the value as claimed by Mr. Sahu. There has to be a presumption from the court that value stated by Mr. Sahu is the right value. How can you pass that order? This is why we are repeatedly asking you.
actually.
And you are giving every kind of answer other than the answer we are
Sir, it
asking
is,
for.
it is very difficult to establish the exact value of the market price. of the-
Then how can I
This is
quote
more than 12 years back.
Mr. maybe any number? Mr. Sahu, can you file a money suit? That I cannot establish how much I'm entitled from that man, but please issue a direction to pay me 20 lakhs.
Actually, that, for that.
But I cannot establish it.
That is not.
I
So,
think, are you not
here,
making the
whatever-
same claim before this court?
Whatever they have established by valuation at the time of.
That,
seizure,
that
we
is estimated.
claim
That is
Yes, that is
estimated,
estimated,
not,
but
not,
it is-
that is not determined.
Yeah.
And it's not binding on them. It's only a random figure they put at the time of seizure. When a good is seized, no seizing officer is required under the law to carry those goods to the open market, get it verified from the open market. What will be the value of that good at that moment? And verified rate will be entered in the seizure. No. Seizure will not take place. In the meantime, we'll go somewhere and take away the goods.
I know, actually, based on factors, circumstances, passed out.
What can we do? What can we do? The value now you are stating will be a presumptive value for this code. And no direction can be issued on a presumption. We can close this, we'll give you liberty to approach again, challenge the auction, get
Yes,
it
my lord,
verified.
that can be.
That much you can. We can allow you to that
Yes,
extent.
my lord, that can be done and after going to the auction.
Another fact, he approached this honorable court. And up to page 131 of the petition. Where the division bench directed the authority to dispose of the original discharge. And working with you to see that the order passed by the department, it page 130.
That order is not challenged.
No, now they have come that earlier order by which the amount is offered to them, that they have challenged, not the auction.
No, I did not understand 131 and the division bench.
Earlier, Lordship, what happened, they approached this honorable court. Lordship, please to see page 131.
131. Same matter.
Same matter.
On if the raw rubber belonging to was seized and responding at the time of seizure. And after this
Page 130.
134, the authorities have passed the order.
Order below. The 4:2 is whether the petitioner is entitled to receive the value of the goods purchased at the time of seizure, or the value which the department received from the seller. Same.
After adjudication, the case was adjudicated by the order dated 28. Rasu, Bastian, Nodding, April 20. So the deputy commissioner, he had taken out a very good logic. Suppose the auction would have fetched something more than the estimated value, then which one you would have been entitled?
The market price that was available at
No.
the time.
He had raised a logic that had the auction price been more than the estimated value at the time of seizure, then you would have asked for the auction price.
Yes, that is.
But when the auction price is lower, you'll be asking for the estimated
Yes,
price.
yes, yes, Supreme Court says that for the wrong of the department, the
Oh,
claimant should not
So where is the wrong?
be. Actually, the
These are,
confiscation is illegal. And
Subsequently, it was.
confiscation is illegal.
but there was no stay in the confiscation, number one. Number two, from the date of confiscation up to the date confiscation was set aside, it was a valid confiscation.
Yes.
Because all judgments are prospective in nature, there is no retrospective effect. So the day the goods were auctioned, they were the owner of the property. And they say that to be fair to the petitioner,
Notice was.
no, we have also, it is on record that prior to auction, due intimation was given to Rintu Bastian. He had every opportunity to participate in auction, but preferred not to participate. So this is where you missed out.
Initially, the.
Not
claimant-
initially.
Yes, ma'am. At the time of seizure, the claimant claimed that you release the goods on provisional basis. Department kept silent.
Mr. Sahu, you are not answering the relevant issue. We can hear you, but it won't lead you anywhere. The argument you are raising.
Fact is, at that time.
None of your arguments you are raising can enable the court to pass an order in your favor. Okay. Please tell us something, submit something substantial based on which we can pass an order in your favor.
My lord, at that time,
We're rising for about 5
In that
minutes. We'll
case-
come back. You think if we have anything more, please tell us.
Yes.
Hmm?
Yes.
But what you were saying, either repeating or using a different expression for the same purpose, you'll find it difficult to convince the court. Give us something substantial. Based on that, I can pass an order in your favor. Otherwise,
yes,
we just can't pass our orders for just
some
because somebody is
other-
asking
some
for it.
Other day citations are the Supreme Court.
Not other day. This is the 5th or 6th other day we are hearing
Yes,
this matter, same matter.
So. my lord,
No more
my
other day.
assumption is, my observation based on this. is-
Other day is today itself. Whatever
Yes,
you
yes.
do, we are coming
Yes,
back. If
today
you have
is-
something, tell us.
This case may be disclosed today, etc.
We are not finding any material to go in it. But
Whatever, at this stage, it is not possible to accept. it
because
as a market
otherwise,
price, it is not-
the estimated value at the time of seizure would have to be construed to be a determined value.
Yes.
That material we are not having. Number one. It is only an estimation.
Yes, yes, yes.
Estimate is not a determination. Determination is the actual value. After looking into all various inputs that are required to be looked into. Estimate is, I take a rough call that it must be this much only.
It's related to 2009. It is 2026. It's very difficult to ascertain the market price at that point prevailing there.
Then you should have taken up these matters at the then and there. On which date the auction took place?
Auction is paid in 2013, I think.
13.
2013.
13, you could have determined the value. You could have challenged the value of the auction.
Actually,
Number one. Number two, you could have participated in the auction and you had the option to purchase the goods, same goods, at your own desired price. Okay. Once you give that money, purchase the goods, and when you get the refund, you would have got back the complete.
my lord, what?
Suppose value of the goods is 5 lakhs, according to you. According to them, it is 1.5 lakhs. Had you purchased the goods at 7 lakhs in the auction, you could have done it. You are so confident that this seizure is illegal. I am going to get an order in my favor. I am going to
Actually,
get a refund.
What in this case?
So let me pay 10 lakhs and purchase this
My
goods.
lord, the fact of the case is.
Who prevented you?
My lord, this raw rubber is a perishable commodity. Within 6 months, that is to be consumed.
Mr.
6 months.
Mr.
But this
Mr.
customs
Sahu,
authority, they have cautioned
Mr.
after
Sahu,
6 months.
we already expressed. The
So-
circumstances you are trying to narrate is not, does not give the answer to the query or answer to the issue.
So,
Enough. If you have something more, tell us, we'll come back. But not, don't repeat the same thing again.
can be disposed by, whatever the available document.
Because we'll say that we have no material before us to make a determination as to what was the value of the goods on that day.
So,
And if advised, you can go and sell the auction that had happened. Once you do that and you get the value of the goods determined, liberty remains to approach again.
yes, that can be done.
Madam Ghosh, called you for one reason. Mr. Sahu, can you please make way for madam?
Yes.
Remain, we'll pass the order after coming back.
Yeah.
If I can recollect correctly, you had argued in one matter that if a government employee has a disabled child, the employee has some kind of a right under the disability law for having a place of posting that will
Convenient.
mitigate the difficulties of raising a disabled child. Somewhere what a year or a half back you raised this argument in one of the matters and you relied on some materials. If your memory goes back to that extent, can we have those materials?
Yes, I have that compilation of,
Please check up and tell us.
yes, Lord.
I also got the study,
Please give
but
it.
it is at my home. Tomorrow I may provide.
Okay, then. Because I remember I passed
Yes.
one order in her
Yes,
case and you
there
have
is a-
made an elaborate argument on that. And produced some material. Maybe that circular also, I don't remember. Because we have one matter today on the same issue. Please, Mr. Mahmood, you also help us with the circular.
But tomorrow,
Tomorrow, definitely. And you also see if you get,
Yes, yes, Lord.
there is no material to arrive at any conclusion that it's a determined value. What will be the determined value? Say, before the goods were seized, the goods were purchased by you.
Yes.
Somewhere you must have purchased.
Yes.
You produced that memo, cash memo of purchasing.
If that, I will actually.
If you produced a cash memo, the value of the goods will be determined as it stood at the time of seizure.
So,
Instead of going to all these indirect methods, going to Calcutta High Court, going to all kind of things, you address the core issue.
page 63 that is available,
What is page 63?
63, there is a certificate issued.
Certificate. What is a certificate?
The certificate is issued by the because.
No, what is a certificate?
I,
And who had issued it?
the supplier.
The same person, that Bastian. So today, Mr. KL will issue a certificate that Mr. KL is a multi-billionaire. Are you to accept that certificate? Forget about it. Produce forget certificates. Produce the original cash memo of purchase. We can provide the maximum to that extent and they'll consider it.
Yes, my lord, the,
Otherwise, no.
I will, by Friday, I will.
No more deferment. It's already deferred for
So-
5 or 6 occasions
Yes,
till
my
now.
lord.
Enough.
Today, after 2 hours, the 3 hours is available.
You don't have to produce it before us, produce it before them.
Yes, that can be done. I will produce that. Based on that.
Only to that extent, because we are declining this relief because the value of the goods as on the date of seizure is, we cannot determine it. So we don't know whether they're. If you have any means to do it, you approach the authorities.
Yes, we
They'll
will
consider it.
Interestingly, before the CISA, what I had gathered from the record, this question was never placed before the trial. Only their contention was that the seizure was illegal. That was decided with the trial.
Yeah, there's a huge lashes on your
Yes.
part.
And Lordship, in both the writ petition, he has not challenged the auction. And it is not the case of the petitioner that he was not informed. He was informed. Lordship.
So once you determine, then you challenge the auction, then you get a order.
If he has any materials, he can.
Yes, I will produce.
Because your lacunas cannot be allowed to be rectified after about 10-15 years.
Hello, you not to pass the order. The direction that we will produce the purchase price of the bill or invoice were they available to the
They
department.
are not specifying anything. Why should we specify? We are not here to give legal advice to Mr. Saul's client. What to do? We'll pass our order.
Yes, sir.
And it's for you to take recourse to whatever
Yes,
there are
yes,
the law. Heard Mr. D. Saul and counsel for the petitioner, also heard Mr. S.C. Kehl and counsel for the respondents in the Customs Department. Customs Department. The petitioner is you are a dealer or what? How to describe you?
Trader.
Is a trader
The raw rubber.
in the petitioner is you are dealing in raw rubber. Is a trader in raw rubber, which they procure from the small registered rubber growers in the northeastern region and operates their business in the name and style of MS Madonna Agencies, having its place of business at Raja at TRP Road, Maskwa, Guwahati. In course of the business, there was a seizure under Section 110 of the Customs Act 1962, made under the signature of who had seized it?
Custom authority.
Under the কি বলবো? By the Customs Authority in respect of 2840.87 kg of raw rubber. Mr. Sao, you may take your seat. It disturbs us if we keep on moving and as if you are trying to say something at any time. If you want, you add it at the end of the order, but not in between. Customer, whether you want here, and the estimated value of the seized raw rubber was stated to be rupees 568,174.74 at the rate of rupees 200 per kg. The seizure under Section 110 resulted in confiscation.
Yes.
Resulted in a confiscation under Section
115.
115 of the Customs Act, as per the order dated.
That's fine. Dated 28 March 2013.
28/3/2013 of the
2013.
of who passed that order?
Commissioner Appeals.
Commissioner Appeals,
No, Lordship, I'm sorry.
Additional commissioner.
Lordship, I'm sorry. Additional Commissioner,
Additional Commissioner Customs.
Custom.
Upon the seized goods being confiscated, they were subjected to an auction on date of auction. on so-and-so, and in the auction, the seized goods fetched a price of rupees
1,55,000.
1,45, 1.1,45,000.
Yes, sir.
000. Later on, as per the order dated so-and-so to blank packet was
Auction was 30th of October 2014, Lordship.
30 October 30/10/2014, date of auction. Later on, the seizure as well as the confiscation was declared to be was set aside by the order dated so-and-so of the OMOC in case numbers OMOC. In the resultant circumstance, the petitioner claims for a refund of the value of the goods that were seized and confiscated. The respondents in the customs department offers the petitioner an amount of rupees 1,55,000, 1,55,000, which includes the auction price of rupees 1,45,000 plus rupees 10,000 penalty that was earlier imposed. Being dissatisfied, the present writ petition is instituted with a claim that upon the seizure and the confiscation being set aside, the petitioner is entitled for a refund of the complete value of the goods and not the value as per the auction. Accordingly, reference is made to the inventory of goods, inventories of the seized goods, wherein the estimated value of the seized goods was stated to be 5,61,174. We take note that in this respect, where is the division bench order? Page 100,
Page
then 30, I think. We take note of the order dated 23/5/2016 of the division bench. Rendered in WA 3012/2016, where the present petitioner was the appellant. And in the matter in appeal before the division bench, the same issue was raised by the petitioner, that as per the estimate of the value of the goods, as per the seizure order, people. The value of the seized goods, the estimated value of the seized goods was rupees 5,68,174. Whereas the respondents in the customs department had sanctioned a refund amount of only rupees 1,55,000. In the order dated 23/5/2016 of the division bench, a representation of the petitioner dated 21/8/2015 was taken note of, which was pending at that relevant time before the authorities. And accordingly, a direction was issued to the Assistant Commissioner of Customs, bracket preventive NER region Shillong, to decide the representation dated 21/8/2015. Consequent thereof, the order impugned in the present writ petition was passed, dated 12/7/2016. While disposing of the representation of the petitioner dated 21/8/2015, the Deputy Commissioner HQRS full stop PREV in the Customs Department took note that by the said representation, the petitioner had asked for refund of the seizure value of the goods instead of the auction sale proceeds of the goods which were seized. The Deputy Commissioner took note of the aspect that after the seizure and confiscation of the goods, in as much as the seized goods were of perishable nature, the department initiated a disposal of the goods through public auction. It was specifically taken note of that the writ petitioner Rintu Bastian was intimated about the auction by letter number, it would be page 134 C number Roman, it's a complicated number. Bluely underline kora ase. By letter number so and so dated so and so of the superintendent disposal of the Guwahati Customs Division, and that the writ petitioner had received the said letter on 18/9/2014, and thereafter on 30/10/2014 the goods were disposed of through public auction to the highest bidder at a rate of rupees 1,45,000. In the order, the Deputy Commissioner also put it on record that the seized and confiscated goods were sold through public auction on 30/10/2014 by following the complete formalities and procedures as may be required to hold a public auction. And further, that it was also done with prior intimation to the writ petitioner. Accordingly, the order was passed that the value of the seized goods is generally assessed after considering various factors prevailing at the time, the place and date of seizure. But the actual value of the goods comes to light only when such goods are put up to sale in the actual market. It also took note of the aspect that the value of the goods was subjected to assessment by the government registered valuer who had valued the goods at the rate of rupees 50 per kg. And thereupon they were put up for auction to ensure that the auction price does not fetch a price less than the estimated, less than the value determined by the government approved valuer. The order also provides that as per section 126 of the Customs Act, year 1962, the confiscated goods that once the goods are confiscated, the ownership vests in the central government, and therefore there is no infirmity in the goods being put up to a public auction. Further, it was also provided that the writ petitioner Rintu Bastian was duly intimated about the date and time of the auction, and that he had every opportunity to participate in the auction, but on his own volition, he remained absent. Mr. D. Sahul and counsel for the petitioner strenuously relies upon the order of seizure dated 24/5/2012, where the estimated value of the goods is stated to be rupees 568,174 at the rate of rupees 200 per kg, and claims that the estimated value there stated therein itself is the determined value of the goods. Accordingly, reliance is placed upon a pronouncement by the Honorable Supreme Court rendered in Northern Plastics Limited versus Collector of Customs and Central Excise, reported in where is the other one, that readable one that you reported in AIR 1999 SC 3643, wherein in paragraph 9 thereof, it was held that the consequence of setting aside the order of confiscation on the ground that it was illegal entitles the SSC, is it SSC or not SSC? SSC, not SSC, entitles the person concerned to the value of the goods as on the date or time when the goods ought to have been cleared by the authorities for home consumption, which in other words would have to be understood to be the value of the goods on the day it was seized. Yeah. We see no reason to deviate from the aforesaid proposition laid on the Honorable Supreme Court that upon seized stroke confiscated goods being declared to be illegal and consequently set aside, the person concerned would be entitled to a refund of the value of the goods as it stood on the day it was seized. But what is noticeable in the facts and circumstances of the present case, present matter, is that in the matter before the Supreme Court, the question for consideration was whether upon the seizure and confiscation being set aside, the person concerned is entitled to a refund of the value of the goods. And the circumstance before the Honorable Supreme Court was not that between the goods being confiscated and being declared by a competent authority to be illegal and being set aside, the goods concerned were put up to an auction. As in the instant case, the goods concerned were put up to an auction, and there is a determined value of the goods as per the result, as per the auction, comma, unless the auction itself is essayed before any appropriate forum on its validity and correctness, it will be difficult to accept the proposition laid down by the Honorable Supreme Court, which is a proposition in general that upon the confiscation of the goods being set aside by the competent authority, the owner of the goods would be entitled to a refund of the value of the goods. be that as it may, even if we consider the submission of Mr. D. Sahul and counsel for the petitioner, that he would be entitled to a refund of the value of the goods as it stood on the day of the seizure, comma. And on principle, even if we accept it, comma, further material would be required before the court as to what was the value of the goods on the day it was seized. The only reference is made to the estimated value of the goods as mentioned in the order of seizure. But Mr. CKL and counsel for the respondent to the Customs Department stated that the estimated value is not a determined value after following a due procedure as may be required. And it is only a tentative value that is put for the purpose of carrying forward the process of seizure. No material is placed by the petitioner before the court to arrive at any conclusion that the estimated value stated in the order of seizure is also a determined value of the goods at the time of its seizure. In the if we put it, it will go against you. Not like that. Mr. KL will say yes. I think your claim is barred by res judicata. Because this one you should have taken up in the earlier proceeding. Earlier proceeding, you say only dispose of my representation. You ought to have raised this issue then and there. Having not done, now it will be res judicata. Should I put it? So you ignore it because you have also made the suggestion. For carrying forward the procedure of the hearing and not a determined value of the and not to put so. As it is the petitioners who had procured the goods that were seized and confiscated and later on put up to auction, they'll be the best person to have the knowledge about the actual value of the goods as it may have been. Which again would also be in conformity with the provisions of Section 106 of the Evidence Act. Burden to prove is on you. But as a dispute has been raised by the petitioners that they are entitled to the value of the goods as it stood on the day of the seizure, the basic material to adjudicate the said issue would be what would be the value as may be determined as on the day when the goods were seized. And in the absence of such material being available, it will be futile to decide the issue as to whether in a situation where the goods were sold by public auction, and if the value of the goods as per the auction is less or not to the satisfaction of the person from whom it was seized, the person would be entitled to a refund upon the seizure and confiscation being later on set aside to the value of the goods as it stood on the day it was seized. We are not deciding his issue. Come for one more round of litigation. In the meantime, liberty is granted to the petitioner to assail the auction of the goods that may have been done by the respondents in the Customs Department as regards its valuation, as regards the valuation of the goods. And we are clarifying that a challenge, we are not given liberty to challenge the auction itself. Auction will remain, only valuation. By producing any relevant material that the petitioner may have, that the value of the goods as determined by in the auction was an incorrect value. Upon such challenge, if any order acceptable in law is made by the respondents in the Customs Authority, the evaluation of goods, to further liberty would remain to the petitioner to approach again to raise the issue as to whether on an entitlement of refund, the petitioner would be entitled to a refund of the value of the goods as it stood on the day it was seized, or the value of the goods as determined in the action itself would attain its finality. The said issue remains open.
Petition will not be, because in paragraph 2, he stated that he procured the goods from small growers.
I know, I've taken note. So you have to bring the small growers with one by one, give evidence. Yes, I sold it for the one grower will say I have sold 20 kg, and I will say I sold 20 kg. If possible, you do it. We've given you one small window, but otherwise.
May I take the record?
Sorry.
May I take the record?
The record produced by Mr. Sikyal and is returned back, is accordingly returned back.
Item 30.
Lordship, the matter pertains to a convention of appointment. On the last occasion, the respondent number 3 has taken time to obtaining instruction. Lordship. This honorable court has directed them to file an affidavit.
If this is compassionate appointment, what was the learned counsel for the petitioner doing for the last 7 years? Don't you have any compassion?
We have filed in the year 2000.
Mr. Counsel, howsoever strong words he may use, we are putting a question. Where is the compassion from the side of the learned counsel to pursue the matter more vigorously? Yet done everything, but not enough. If it's a compassion, immediate succor should be provided. And you wait for 7 years for the matter. You yourself spoil your own case. Digging your own grave, what is it? On the very first day, you could have pointed out that this is the illegality. And if it is to be accepted, you would have interfered and sent it back, so that the person can get a consideration on time. Now, after 7 years, what will they do? If the litigant can wait for 7 years and be satisfied with the existing financial condition, there is no need for any compassionate appointment. You don't need it. It's not a legal right to get a public employment. It's a right only to overcome the immediate financial hardship. If your client can afford to engage a counsel who will not vigorously pursue the matter for 7 years, that means the petitioner is happy with the present financial state. Who is your senior, K. Golita?
A. Sharma.
A. Sharma. Don't you think so? counter affidavit, then what? These are all small trivial matters. Point out to the DLC if placed, where is the illegality? If we accept illegality, we'll send back. If it is not there, you are not entitled. Where is the requirement of affidavit, counter affidavit, this, that, all kind of things, and continue for the next 7 years?
If I may place an order, to the order of the rejection, the order of the DLS.
After 7 years, you should have done it 7 years prior to it. Yes, Mr. Pigu.
Not, on the observation,
See, most of the matters you must have noticed, why do we take it up at a motion itself? So that if somebody has to get something, get it immediately. If you don't have, you don't have it.
the financial condition of the petitioner was better than the other candidate. That was,
But that's why it was rejected.
That was the ground taken, but then they have never verified, physically verified in the Delhi hospital petition, or for that matter.
They have not physically, why do you say they make this statement, they had not physically verified?
Because though they have taken the ground, there is no explanation as to regard on what basis they have taken the ground for the
No.
financial condition of the petitioner.
The other, they made a statement, the other person were financially worse off than this petitioner. Why should you disbelieve that statement unless you produce some material to us to,
The petitioner is still an unemployed.
Sorry?
The petitioner was still an unemployed, educated unemployed at that point.
every educated unemployed has no right for a compassionate appointment.
They were in a
You go and apply in the job market, get your employment. Compassionate only under a specific circumstance.
The last option, this honorable court has observed whether on what basis they have taken the case of the petitioner for rejecting the case. Of
The respondents to produce the records of the district DLC which may have considered the application of petitioner for compassionate appointment and rejected upon an interstate comparison of the applicants that a petitioner is financially worse off than the others, is not financially worse off than the others who were recommended. Just again.
31 and 32.
By the last order 13/9/2023.
Last time is paucity of time. Before that, respondent may provide information existent of vacancy in the previous psychiatrist in the consultation meantime, for the juniors retired. I think some promotion or something, no? And in the meantime, one of the promoted men had retired.
In the first 3119, I have challenged the promotion of respondent number, the.
BP Bora appears for the private respondents.
But in that first case, there is an interim order passed by the school directing not to promote the respondent number 8, who was respondent number 6 there. And with that situation.
But in violation of interim order, he was
No,
promoted.
they have not violated, they have not promoted, they did not promote him. Nor they have promoted me, but my juniors have been promoted. So those are. those
The
are
two
chal-
contesting persons are not promoted, others are promoted.
Other juniors
Very
are
well.
promoted. So but in the 7800,
So,
I have challenged.
so now today, what are you required to do?
My lord, admittedly.
No, whatever has happened has happened. Today, what can you do?
My lord, Lordship wanted to see whether I can be accommodated because they are admittedly junior to me and not to interfere with.
Can you
their-
accommodate this
their
petitioner?
promotion. This is the vacancy position.
No, no, can you accommodate him? That is, you have to say. If you,
I have to take instruction, man.
how much more instruction you want from 2016?
Vacancies are available in the office. I have obtained the.
We'll take up in the second half, get your instruction. Whether you can accommodate this man. If you yes, so we'll record your statement and close it. If you cannot, we'll decide it.
33.
Years.
As per order 25/3/2022, madam. Instruction was madam.
What instruction you want?
Okay, in respect of letter dated, madam, 11/11/2014, madam.
What is the issue raised?
Madam, regarding compassionate employment, madam.
Compassionate.
Yes,
Was it placed before DLC?
yes, madam.
Which page?
Madam, case number 26, madam.
Who is this petitioner? Meenakshi Borua, recommended. Was it placed before SLC?
Then forward, my lord, then after.
No. Was it placed before SLC? Not placed. Place it.
Well, it was placed before the DLC, but.
DLC recommended.
My lord, there was the technical defect, my lord. Two petitioners, my lord, two candidates having the same name. So another candidate was sent, my lord. The petitioner's case was not placed.
But you have to send it.
My lord, will place
Just
it.
because you made a mistake of somebody sending somebody,
My lord,
the genuine man cannot be denied.
that it has to be placed before a DLC. my lord.
Not DLC, SLC. There is a recommendation. Send the recommendation of Meenakshi Borua, daughter of Ponamai Borua. If you have sent another Meenakshi Borua, you deal it with yourself, how you want to deal with it. But Meenakshi Borua, daughter of Ponamai Borua, it should be go to the SLC. And SLC will not reject it on the ground that another Meenakshi was recommended. Okay. Third, Mr. Gogoi and Council for the petition. Also heard the spoken for the Elementary Education Department and Mr. Girin Pebul and additional senior advocate for the Chief Secretary and the Deputy Commissioner Lakhimpur. The father of the petitioner, mother, name of the mother, where is it? Where have you written the name of the mother? Where is she worked and when she died? Paragraph 3. The mother of the petitioner, Ponamai Borua, was an assistant teacher in the Bipuria ME school. And thereafter, she was the headmistress of the school and died in harness on 22/10/2010. On her death, the petitioner submitted an application for compassionate appointment on again, no date. 10/1/2011, which was placed before the DLC of Lakhimpur district in its meeting of 10/8/2011. Full stop. Upon evaluation of the existence of a vacancy, the petitioner Meenakshi Borua, daughter of Ponamai Borua, was recommended for a post of assistant teacher under grade 3 category. The grievance raised is that the said recommendation by the DLC in its meeting of 10/8/2011 had not been placed before the SLC. Mr. Girin Pegu, learned additional senior advocate, upon obtaining the information, states that another Meenakshi Borua was incorrectly referred to the SLC, and therefore the writ petitioner Meenakshi Borua, daughter of Ponamai Borua, was not referred. As there is a recommendation in favor of Meenakshi Borua, daughter of Ponamai Borua, for compassionate appointment to a post of assistant teacher under grade 3 category, comma, merely because by mistake another Meenakshi Borua was referred to the SLC, cannot be a reason to deprive the petitioner Meenakshi Borua, daughter of Ponamai Borua, in whose favor there is a recommendation of the DLC, to be placed before the SLC. Accordingly, the recommended DLC in favor of Meenakshi Borua, daughter of Ponamai Borua, be placed before the next available by the DLC dated 10/8/2011, be placed before the next available SLC. We are clarifying that the SLC shall consider the recommendation on its own merit and should not reject it either on the ground of no vacancy being available presently, in as the vacancy may have been consumed by some other candidate, nor it shall be rejected on the ground that the earlier rejection was of the year 2011. The SLC to also take note that the recommendation of Meenakshi Borua, daughter of Ponamai Borua, was for a post of assistant teacher, which carries a corresponding qualification. And although in the year 2011, the petitioner may have been qualified, but going by the present qualification required for the post of teacher, she may or may not have the qualification. The recommendation made of the petitioner in favor of petitioner shall not be rejected also on the ground that presently she may not have the qualification. If that is the case before the SLC, and as it is and as her recommendation was not placed before the SLC because of an illegality by the respondent authorities, the SLC may consider her recommendation or compassionate appointment against any other suitable vacancy for which she may have a due qualification as of present.
One of the another Meenakshi Bora is wife of late Pitambar Sud. That may be recorded.
The other Meenakshi Borua who was sent, who is stated to have been incorrectly sent instead of the present petitioner Meenakshi Borua, is stated to be Meenakshi Borua, daughter of Pitambar,
Wife of late Pitambar.
wife of late Pitambar
Sud.
Sud. Compassionate.
My lord, DLC rejected my lord 849.
On what ground?
My lord, we could not file the application within time. That is 1 year.
Yes, Mr. Sakya, what do you say?
Madam. Considered matter.
Same order. 1 year is not mandatory. Directed. That will not bring in any law of limitation. Call even after it format. Third, Mr. Anhogl is also very. He's a calculator. Why we are sending this back, Mr. Sakya? Ultimately, law requires that whosoever is financially worse off, give it to him. Law does not require you to filter, keep on filtering out candidates from stage to stage. If you keep on filtering, the person who actually deserves may be left out, and the person who does not deserve may be having a lot of financial resources. You will appoint him. This will ultimately defeat the purpose of compassionate appointment. This is not a regular appointment that I'll select only the fittest. Delay and lashes. One who sits over the right loses the right. These are all inapplicable. If you forget about all these technicalities, if you have 100 applicants, consider 100 applicants. If you have one post, give it to the person who is financially worse off. That is the purpose we have brought this scheme. This scheme was never brought in to give employment to anybody. So if you do all these things, you lose the original purpose. Sorry.
One of the central government notification regarding the appointment of professional appointment postal department. I find the notification a very beautifully guidelines the frame out the guidelines. How can
we don't go by central government? We follow Achyut Ranjan Das and Faziran Nessa for state of Assam. Only criteria is inter-se financial comparison and nothing else. That's the only, not even suitability. That one man will be more suitable for this post than the other one, we give it to the, not even that. You may have to give to the unsuitable person also. Comparatively unsuitable, I mean, not the absolute unsuitable. Just because most of these people think that they are giving employment, you are deviating from the original purpose and getting into all kind of different kind of technicalities. So what should we do? Send it back. If you have not done it. On what ground it was rejected? That after 1 year, which page?
Well, page 49.
49.
My lord, serial number 80.
One year also you can reject it, we don't mind. Suppose you have materials with you to show that during this 1 year, this family had acquired some financial gains. Therefore, they don't need it anymore. We'll accept it if you reject it that way. And the only one line, if you have survived for 1 year, you can survive more. Do you know how he had survived? No one knows that. He may be having a lot of resources or maybe begging around also. Begging around survival is not a survival under the law. Who is this man? Sikdar Golab Hussain. Which page? Sikdar Golab Hussain.
Serial number 80.
Name of the father?
My lord, date SM
Huh?
Rafiqul Islam.
Father Rafiqul Islam, head teacher, 1979 number, Hatmukhi Chiknir Par LP School, Borpeta district. Died in harness 1/8/2015, application 3/4/2017. The application was placed before the DLC of Borpeta district in its meeting of 2/11/27. It stood rejected by providing that the petitioner cannot be recommended as he had not applied within 1 year. It is no longer res integra that the requirement to file an application within 1 year is not a mandatory requirement, but a directory requirement to facilitate the process. Petitioner applied on the deceased died on 1/8/2015, whereas the application was made on 3/4/2017. That is where it ought to have been made by 1/8/2016. It was made after 8 months thereof. No material is available that during these 8 months, the family had acquired their financial status, which will enable them to, which will no longer, from which it can no longer be concluded that they are financially well off. Remanded back to be considered as per law, to be placed before the next DLC.
Item 35.
I proceed with one time to file it.
Petition, affidavit. Ki Gogoi for higher education. It's for, how much time you want?
2 weeks.
2 weeks time to file affidavit. Yes, ma'am. You want to file affidavit?
Yeah.
You already filed, okay. List after 2 weeks.
36.
Yes, Mr. Khan.
This matter is related to provincial.
As Chutia, please for 4 weeks time to file affidavit. Filed. Mr. Ganesh Pegul and praise for further 2 weeks time to file the affidavit. Pray allow list after 2 weeks.
37.
Lordship, my lord, in this case, we are the head of
different institutions and coordinators. Our institutions were granted permission to take admission of certain trainee teachers. And we have taken also admissions of those teachers. At the 11th hour, the government stopped the same. Then, my lord, we filed various representation, and on the basis of those representations, which may be seen page 48 of the writ petition, the government asked repeated letters to the director, SCERT, to hold the examination and to provide them registration card. Earlier, they took the stand that the director is in behind the judicial custody. Now she is open. Now she has filed an affidavit. Director has filed an affidavit.
Director has gone to judicial custody. What happened to the director?
No, no.
Huh?
No, no,
Director of which department?
But not director. The additional secretary, Government of Assam Elementary Education Department. He was the executive chairman come director, ODL cell SCRD.
Ah.
He got entangled with some money misappropriation case, madam. And
And original post is
it is my lord, joint secretary.
joint secretaries.
Yes. Camp director.
What kind of joint secretary you are maintaining?
More than 100 crores, my lord.
Uh,
Now, my lord, this particular ODL.
So
cell
now
is
the person is back in service.
No, no, no. It's the new my lord.
Achha, this is a new incumbent,
Yes,
earlier
yes,
one.
long-
Ah, that is
My lord,
okay.
our permission is this, my lord. Now, she has filed the director has filed affidavit. Now, the
Now, who
director
are these
says
petitioners?
In the year 2000,
Mr.
Two.
Mahmood, who are
Hello.
these petitioners?
petitioners are the head of the institutions and
Head
coordinators
of institution.
of different institutions. And they were
No,
provided.
they- what kind of institution?
There are some colleges, some other institutes to provide education.
That is a the private institution or
Private
government?
institutes as well as government also. As well as government also.
So they are head of some institution.
Yes.
And
they-
what is their legal right you are
The
espousing?
legal right means our right has been given to us that you get the students, teacher, students admitted and train them, and in exchange we have paid. A good
What kind
amount.
of institution is this? A regular school or?
College, some.
I know term college is after class 12 it is college, below class 12 it is school. But what kind of a school or college? What do they do? They give regular education or some special education?
I have given their identities.
They are normal regular schools and colleges.
Some are regular, some are on the way to go to become regular. That may.
No,
our
which
identities, there are two.
which communication allows you to recruit someone?
Yes, that lordship may kindly
Is,
see page 16.
16.
Not only page various letters. Kindly see page 16. From Sri Shivali Devi, the Joint Director to the Government of Assam Elementary Education.
Mr. Gogoi, what are
Well, these institutions, they used to give my lord this diploma in elementary education, that my lord certificate. Pursuant to some.
no, this institution, if somebody reads in this institution, he'll be given a diploma in
Yes.
elementary education. So they are institution to confer diploma in elementary education. They are not regular schools and colleges.
That my lord, they are actually training institute, my lord. And my lord,
Training
this-
institute.
yes. And the persons who are admitted, they are already in service employees, right? They, my lord, get admitted, my lord, they used to get admission to have this particular diploma.
So for teacher,
Right.
DLED diploma is necessary.
Yes.
So state has created this institution.
Right.
If you study in this institution, you'll get a DLED diploma. So now what is the grievance of the petitioner?
My lord, from my lord, May 2020, my lord, there is no such extension given for this particular course.
This,
They said that, my lord, they are
this
admitting
no,
students.
for the course or for the institute?
No, for this particular ODL course, for the diploma in elementary education. That is what the.
So these institutions now will no longer be able to confer diploma
At least for this part. Yes.
for this year.
Yes.
Now what will they do? They'll
That-
close down or they have some other function?
That part, my lord.
This is an additional responsibility given to a regular institute, or they are created only for this purpose.
That part. ODL, the
The course can be given either on a regular basis, on a face-to-face basis, what we call, and on the ODL
ODL
process,
means?
but that is the online distance learning.
Very well.
So, but this.
No, what I am asking, suppose there is our Don Bosco school. It's an existing school giving regular education.
Yes.
They are also given an additional responsibility of conducting this kind of courses by some arrangement. Now, if you stop this arrangement, the school will continue in its original function. These institutes are in the nature of that kind, or these institutes are created only for the purpose.
Only for this purpose.
Only for this
Only for
purpose.
this purpose.
Now, moment you stop this one, what will this institute do?
Well, this is the state institute, if I'm not wrong.
No, what will they do? What function will they discharge? So now, today, suppose you have a high court, but somebody says no petition will be filed before the high court for 1 year. What is the high court supposed to do?
So this,
Similarly, if an institute is created for this course, and you say for 1 year don't admit anybody, what will they do?
these are these, what I have understood is that these institutes are private institutes. The government runs the DLED course, which is recognized by the NCT. Now, we had authorized them to be centers to take
Study
classes.
center.
Study center.
Means you conduct
Now,
the course
they-
and do this thing.
Since they do not perhaps meet the regulations of the NCT or the regulations that we.
So
set
you have
standard,
withdrawn them.
So we tell them that you are not supposed to now do that part of the duty for us. We'll have it done by someone else. So that online or that ODL center for the HCRT to give this course has only been stopped.
All for the record to show cause as to why the leftover trainee teacher. So to get the DLED course, you may either be a trainee teacher or you may be a student also. Both of the petition shall not be provided registration number.
The persons who were working in that ODL cell, they were released from the ODL cell. There were
Who?
certain, in our SCRT, in the SCRT.
Okay, in
we
the
have
SCRT,
certain,
who?
number of people who are working with the ODL cell.
Huh.
Now, since the course has been completed, the 2 years course is now complete, we are not giving the centers to any further person. Persons who are working in this ODL cell are released from the ODL cell. We don't
No,
need
that
that
I
further investment.
understand.
That is the case.
Firstly, produce what scheme you had to engage this institute. And secondly, the policy decision you had taken to withdraw it. If we examine the validity of these two aspects, maybe we can decide his case. Because he is saying only prayer is, I was given the responsibility to conduct this course, please allow me to do so. Continue to do it. I think that is your
They
prayer.
have also taken huge amount from us, which we have collected from the student. They have accepted. And my learned friend has submitted, which are beyond record. Kindly see page 75. They say that in the year 2020, this scheme has been closed. Actually, that is not correct. Kindly see page 75. That is my affidavit in reply. I have filed page 75, Annexure B. So the commissioner and secretary, elementary education department, please find there with a copy prayer petition, so and so, so and so. Please examine the matter and consider for inclusion of left out teacher trainees of 2 years DLED old under SCERT Assam in
But
the.
this is by the chief minister.
Chief minister.
A
Then
note of a
kindly
chief
see-
minister
Yes,
is not implementable in a court of law.
Page 76, this departmental letter.
Hmm.
I am coming one after another. This is from the
Allowing
secretary to
left-
the government of Assam Elementary Education Department. So it is writing to the director.
From SD Sharma, secretary to executive chairman,
Yes.
ODL SCRT.
The
This
clear
is-
instruction allowing the
It
leftover
refers
taking.
to the environment director imposed recommendation by minister along with representative from.
Then Lordship kindly see page 77. This is another letter from the
Understand.
director itself.
Then after that,
Director itself, page 77.
after that, what is the final decision taken?
They have not taken decision. The students are pressing hard. They are behind me. They are also threatening us that we will file police case against you. What's your fault? We are suffering.
Yes, Mr.
It
Modi.
was of 2017. It was closed in May 2020. Page 80.
If it has closed in 2020, why the secretary writes in 2021 then? It's a lack of communication between the authorities, it appears.
Secretary's letter is 3rd of March 2021.
And you closed in 2020, you say. After
Yes,
closure, why the
yes.
secretary writes then?
How it- And request you kindly to resubmit the same in the given prescribed format and close their video. It should be sent at an early date for proper verification of the training. And we have fulfilled that. Best 82 kindly stick for a moment.
You do one thing.
Vale.
You take up this one,
Okay.
communication of this one, pass a reasoned order thereon and bring it to us. Then only the whole picture will be clear, what has happened, what has not happened. Because of this communication,
Right.
these petitioners are intaking students.
Okay.
They are taking money from them also. And once money is taken and they are not allowed
We have
to,
also given the money.
so definitely somebody will go for police case against them.
Well, let me have clarification in regard instead of passing a sitting order or something.
No, we are not passing any order. We are
No,
just,
no. So far as our part is concerned, from SPR, let me have the detailed instruction regarding the scheme and the present status. What will happen to the students if they are still being admitted by the
See,
institution?
you introduce a scheme.
Fine.
You allow it to proceed as per the scheme.
Lord.
Later on, there is a confusion. Some quarter feel that it is stopped, some quarter feel that it is to be continued.
Lord.
In the confusion, the people who are the beneficiary of the scheme,
Lord.
they keep on intaking of students.
Fine.
Now the students are creating problem that once we are in, you give us back what we are supposed to get. And these institutes are neither here nor there. They don't, had it been very clear, say from one day, you instruct them not to intake any more students
Well,
because we have stopped the scheme.
64 of this petition of the affidavit filed by SPR.
64.
Page 64. There is a communication dated 19th of May 2022. Kindly-
64 is appointment of somebody.
No, thereafter,
Oh, sorry,
following are to
60.
be noted while assuming the assignment. All activities relating
for-
to state open schooling of Assam is kept in abeyance by notification dated 11/4/2022, copy and close. All relevant records, documents of
No,
ODL cell-
consequent upon transfer of Hewali Devi. Niroda Devi,
will have to be
director is
provided
entrusted to
detailed
be this
report
so
on
and so.
functioning of the process.
Following are to be noted while assuming the assignment.
Thereafter, when the report has been submitted to the
No,
elementary education.
Mr. Gogoi. Suppose today High Court is giving the benefit to hear the litigations filed by the litigation.
Right.
Okay. Tomorrow, High Court decides that we will not entertain any more litigation. Fine. Somebody somewhere takes a decision which is neither on public record nor on this thing. One authority writes to the other, do this, do that. What will be the legal position? If we have taken a decision to stop, take a definite decision, give wide publicity to it,
Lord, yes.
then perhaps they would not have taken in any more students.
Lord.
But you are neither doing here nor there.
But my lord,
One officer will write, please go ahead.
this decision will have to come from the elementary education department.
Sorry.
Their instruction that
See, there is a political decision at page, I think, 74 or something, Mr. Mahmood has pointed out,
Yes.
that it will continue. Fine. Pursuant to the political decision, there is a communication from the secretary of the department, that is the government.
no, there is not a decision. It says, my lord, please examine the matter and consider for inclusion. So what they have done pursuant to this.
Whatever it is,
Yes.
it's a decision. It's a political decision.
But my lord, this is
But
it is
political
addressed to
decision
the
is-
elementary education department.
Understand,
not by the
political
SPR.
decision is never that you stop it.
No, I'm not saying that, my lord. Whatever final decision will have to be, my lord. from
We
the
don't know,
elementary education
Mr. Gogoi. If some existing benefits being given to a private entity
department.
to undertake some state responsibility,
Fine.
you are always at your discretion to stop it.
Stop.
But the stoppage should be loud, clear, and transparent, and should be known to all.
Fine.
One entity will give the indication it is continuing. Another entity will give an indication it is not continuing. In between the two conflicting stands of the two different entities of the same government, these people are caught
Fine.
in between. And they are caught in between to the extent that without there being express order requiring them not to intake any student, they are intaking students. Once the students are being taken in, an independent legal right flows in favor of those students to get the benefit for why they are in. This is the situation
Yes.
we are presently facing.
The only thing I like to point out is that it is the elementary education department will have to take a call. As per their
Take a
instruction,
call.
the sale is running. Now it is department.
And if you have already taken a call, which is not clear,
Yes.
make it clear, it will be prospective from that date. Whosoever had been taken in, complete that process.
In that regard, my lord, let us both have the inspection, my lord, what is the.
Definitely. Otherwise, what will you decide?
Lord. For your information, my lord, we have stopped the taking admission of further students. Only the already got admitted.
Already got, that's
Yes.
what we are
Only
saying.
One time.
Because
Special case.
after this confusion arises, some students are already in. You can't put them in jeopardy. Upon hearing Mr. M.U. Mahmood, Land Council Petitioner, Mr. B. Gogoi for the SSA and Mr. R. Mojumdar for the Elementary Education Department, what is discernible that the State of Assam India Education Department had a scheme or otherwise allowing certain private entities as study centers to impart education, which may ultimately result in the diploma called DELED. D full stop EL full stop ED. At some level in the education department or in the SSA, there appears to be a view that such arrangement is to be discontinued. But again, at some other level involving the entities of the same department, communications are available, which gives the indication that the arrangement is to continue. In the resultant confusion, the petitioner institutes had gone ahead with further intake of students. It is stated that in the meantime, there is a clear instruction not to intake further students, and from such instruction onwards, the petition institutes are not intaking any further students. But the students who had already been intaken during the period when the confusion was prevailing, is the issue before the court as to what would be the fate of such students who are already in.
They have also paid good amount. To
That
them,
is-
to us.
That is between you and them. Amount we are not concerned. We are on the legality of the issue. And money will not give greater weightage to the legality. Both Mr. B. Gogoi and Mr. R. Mojumdar, Land Council respectively for SSA and the elementary education, praised by adjournment to provide the view of the authorities to mitigate the aforesaid circumstance. List on Swens.
It will be SCRT, not
SCRT.
For your information, my lord.
No, you give us in detail. Give us in detail.
Only one time we paid with nothing. My lord, for your lordship, kind information, I have given the certificate.
You have
And
given
also
the
to our that circular. And 2 orders of the.
Oh, thank you for that.
Okay.
One matter is there, this issue
I
comes
have
in.
not provided you.
Please, thank you.
In item number 35, interim order is there. It may can be complete.
35 to 2 weeks.
35 is already over.
Interim is there, that we can.
Thirty-eight,
Mr. Mohanto,
It leads a lot. Lordship, the council for the respondent number 6, Mr. P. Bharadwaj had to go back home.
sorry,
Due to his deteriorating health, Mr. P. Bharadwaj, council for the respondent number 6.
6 is a private respondent.
Private.
Adjourned on the inconvenience of Mr. B. Bharadwaj, Land Council for respondent number 6.
My simple price to fix a date, Lordship.
To be listed again on
Black price.
39,
Interim to.
yes, Mr. Mojumdar.
Lordship, and because the order dated 16/10/2023.
No, 30 to 30.
Another man is appointed.
My lord, yes.
He is entitled,
Yeah,
he is
38 to 11
processed,
December.
but in the final stage, this man is ousted, another man is in. What you do with the other man, it is your problem. This man should be in.
Now, perhaps, my lord, that was not the
38 to 11.
exact. From what I have been given from this, what has happened is, this petitioner, along with others, had approached in a title. In the title suit, there is an order which says that she was not represented, did not pursue the title suit, and therefore it went by default. That is how the title suit was. But in the final decree, appointment orders were also to be issued in her name. Her name is in the summary.
So we go by the decree.
Yes, no, we are not disputing the fact.
If there is a conflict between the judgment and the decree, the law says decree will prevail,
What I was trying to
Yeah.
say is,
not the judgment.
now she did not go for an execution of the suit. Nothing was done at that point of time. There is a letter from the DI of schools where I found with the department that she did not pursue it with the department at that point of time also. In the meantime, those plaintiffs, they came back before this honorable court, filed a writ petition. She was not a party. They filed a contempt petition. She was not a party. So department at one point of time, her existence in the department was almost not known, because people kept changing, and there is also a report saying that there was a fire and all records were cut. Those persons who continuously pursued the matter, those 5 out of the 6, 5 persons pursued. These 5 persons' names are there, and the person who is 6th is also in the select list. He is not a person from outside the select list. He is also there.
But
These two persons-
where are the two documents? One
What?
containing the petitioner, one not containing the petitioner.
99, page 99. Lord.
99. Your submission would have accepted it had this petitioner been excluded all along.
Yes.
You did not come, your right is extinguished, we are not recognizing you.
Mm.
That's a very good argument you have raised. We would have accepted it.
We are not, I'm not on the extinguishing part of it, my lord. Lordship wanted to know why
So,
the name
but-
went missing. How the
but-
name was replaced,
But in page 99,
my lord.
there is an order by the director right or wrong or whatever it is, action made to intimate this office for appointment. This contains Khadija Khatun. Had you not included Khadija Khatun, we had accepted your submission made today. That we have not included in 99 because Khadija Khatun had not pursued her
Yes.
case. Very well. But pursued or not pursued, once her name is included for appointment, at this stage, an independent legal right has bestowed on upon the petitioner for appointment. Now, at this stage, in 2001, when you actually issued the implement the aspect, you cannot delete Khadija Khatun
We could not.
without following the due procedure of law and include Azmat Ali.
All these.
Azmat Ali may be right. Azmat Ali may be a person who was in the waiting. Khudeza gone, Azmat comes in, you may be right. But
Khudeza should not be denied.
once Khudeza is included in 1999, the legal right that flows from this document, which has a background of what you have already stated, all the 6 flow from some title suit. Meaning thereby that in spite of everything, department always understood that Khudeza is also included in the process.
Who was to be given the benefit. Now,
This right cannot be taken
we are
away.
not taking away that right. What happened?
Then give back the right.
That was taken up in an earlier repetition.
Which one?
Recent repetition, there was another repetition by the same petition. That repetition was dismissed. Petitioner went up in appeal. Lordship has the appellate order.
Page number.
Division bench total 154.
Page number 154. Yes.
Lordship comes to page 155. Learned counsel for the appellant has drawn our attention to a letter that is issued by the Director Elementary Education to the Commissioner and Secretary and has submitted to the petitioner's application for grant of SIU approval is already under process.
Appellant is the state.
My lord, yes. No, appellant is the repetitioner whose repetition was dismissed.
Okay, fine, and submitted.
Further, by referring to paragraph 6 of the affidavit in opposition filed on 2011-2020 by the Director Elementary Education, learned counsel for the appellant submits that although the petitioner was selected in the year 1957, her case was forwarded to the government for the first time on 28.
Petitioner is 57-year-old now.
Yes. So now, therefore, at the end of the day, the Honorable Division Bench directed us to send it for SIU approval to the finance, leaving it open whether the finance should grant the SIU approval or not. That lordship will find at the last lines of last paragraph of page 156. Under these circumstances, we allow the appeal by directing the state respondents to consider the application filed by the writ appellant for grant of SIU approval. As per the aforesaid letter dated 31/5, as well as the statement made by the state in the affidavit in opposition, which reflects that the matter is under consideration.
So,
accordingly, so and so is set aside with direction to the respondent authorities to complete the process which is pending before the authorities as indicated. Now, somehow, my lord, now the grievances at page 158. A speaking order was passed at page 158.
160, 160.
I'm sorry, 160,
161.
I'm sorry, 160, 161.
Hmm.
Now, here the commissioner and secretary, the secretary then, at paragraph 2 of the finding, it is seen that the petitioner joined as party plaintiff in title suit number so for seeking appointment of assistant teacher. The district judge Hailakandi was pleased to allow the state title suit by directing to appoint the plaintiff. However, paragraph.
So understand the query that we are raising, that page 99, legal right had accrued.
Earlier.
I understand. No, earlier one remains only SIU approval. The judgment of the division bench confined only to SIU approval. SIU approval is no longer a discretion of the finance. Finance will look into whether this kind of the post and appointment should be made or not. But in doing so, you'll also have to take note of the 99, page 99. There is no finding by anyone, either by the division bench or by this order impugned, that page 99 is to be ignored. And you cannot ignore anything. So, by conduct leading to a legitimate expectation and almost a promissory estoppel, by page 99, a right had accrued to them. And this right cannot be taken away by a legal opinion given, now interpreting the. If you want to do that, you have to withdraw page 99 by following the due procedure of law. Opinion may be right, I don't know. We are not commenting on that. If you want to act on the opinion, it is not to ignore page 99, but to withdraw page 99 by following the due procedure of law, not otherwise.
Page 89 may also.
Otherwise, it will be arbitrary.
Page 89 may also find it, the division bench.
And implication of the title suit order had all along been understood up to page 99 in a particular manner. When the time to implement it comes, we start understanding it in a different manner. This cannot be, number one. Number two, under no condition that other Azmat Ali could have been appointed. Because Azmat Ali was not processed. Maybe Azmat Ali has his own legal right, whatever it is, but he also has to be processed in the same process. Suppose today you hold one selection for 6 number of posts. You select 6. Fine. Midway through, somewhere you delete the 6. To fulfill that gap, you cannot bring in another man from some other selection and say, now as the number 6 of this selection is, we feel is out, let me bring the selectee of some other end and make him the number 6. If Azmat has an independent legal right, his case should be processed independently as per his. He cannot be interjected and brought in this process. So both of these, we find it a little untenable.
I checked the petition opposition at page 146, which was filed in the earlier writ petition. We have almost also applicable to this extent.
But difficulty is Mr. K. Mojumdar.
Lordship,
When the person is 57-year-old as on
Lordship,
2022,
Lordship.
now whatever they
Lordship,
do,
with all respect, Lordship, she is now about 57 or 58, Lordship.
not now, in 2022 she was 57, I read it somewhere.
But,
In the
read, Lordship.
Hmm.
But as per page 89, Lordship, admittedly, Lordship, at least one day she should get a justice, Lordship, from this honorable court. To get her appointment, Lordship, she is deprived. Lordship,
But
pray.
no, but then again, what about the maximum age limit for government employment?
because of the fault of the authority, Lordship, I am out, Lordship.
Then understand. Then the notification of 1951 says, if inconvenience is caused because of any acceptable reason, the upper age limit has to be condoned. Now we have to go and get it condoned.
Lordship, at least there.
Mr.
I pray, Lordship.
Mr. Mojumdar, think about whether you can give pension to this person. Along with those other 5 who were appointed, who will be getting in the same terms. Need not appoint her. Because now for a few months away, I don't say that go and appoint somebody.
Yeah, after appointment.
There, we will provide for you.
We can move the governor
We,
to condone.
no, we'll provide for you that there is a deemed appointment of this person. We'll create a legal fiction. Judicially, we can create a legal fiction. And upon creating the legal fiction, let this lady enjoy some pension at the age of 60.
Page 156 was the honorable.
Otherwise, the next option for us will be compensate the person. Pain lakhs. Don't appoint her because of all these technicalities. Compensate her. Compensate her along with interest. It will be more burdensome for you. But we can compromise it to the extent we'll create a legal fiction of a deemed appointment, process it as a pension case. After all, illegality had been done, which is writ large. So we can't ignore that part. Think over. We'll take up after a few days. Yes, Mr. Gogoi. Illegality had been done, but that doesn't mean the illegality continued till the person reaching almost 60 years of age, so therefore nothing should be given. And Mr. Mojumdar, technically also your objection we cannot entertain it will be barred by res judicata. You ought to have been taken, that ought to have been taken in the earlier proceeding. What you are raising now, this opinion, legal opinion, etc., and other things ought to have been taken.
That opinion has been sought for after the writ appellate order.
I understand. So that this opinion will not hold any field.
The writ appeal order, my lord.
So it will not have any relevance from that point of view.
I'm not impressing upon it, but one paragraph, my lord, which will perhaps also require consideration is at page 156, the second last paragraph says, after hearing the learned counsel for the parties, we have the opinion that whether the state authority should be willing to grant SIU approval at this stage. After
That is only SIU approval. It has nothing to do with the legal right of the petitioner. SIU approval does not determine the legal right to be appointed.
The whole matter, the originally the appointment orders were perhaps
Sorry,
issued
no,
because the
no,
approvals of
no,
the
no.
SLC and the
No, we can't accept that.
SIU.
We can't accept. And firstly, and secondly, SIU is almost a foreign element as regards the service law of appointment. SIU is only a convenience part of the finance department. A long accrued right cannot be again made subject to a what you call SIU.
SIU is perhaps because they do an inspection to see that it is one man, one post. For that purpose, the SIU approval.
See, when a man is litigating for 35 years, where one man, one post the concept comes from. God knows what happened to the post. God knows only what happened in between in 35 years. These are here. Suppose somebody advertises there are 5 posts available, but you are trying to recruit 6 persons. Only there the relevance of SIU, not otherwise. SIU cannot say that out of the 5 who is to be recruited, X should not be in this one.
SIU slowly limited that particular post.
That
They will
particular
only see
thing.
whether this particular post is required or not.
Require, that's all.
Now in this sort of cases, my lord, when a person, when a proposal is given along with the name of a person, in that case also they will only examine about the.
But not on the legality of the person to be that. Only on that, only on the financial aspect.
Along with the name it is provided, they will definitely examine whether it is.
That must be definitely. If there are 5 posts, you cannot recruit 6 men. It will create all the problem.
So, some time, my lord, I'll get the discussion.
How much time? 4 weeks. How much time? 4 weeks.
Oh, my lord, little lesser would do.
Uh,
A little lesser would do.
List on 15 December. 15.
14.
14.
14, then I will decided.
And on which day the judgment will be delivered? 14 will be heard, no difficulty.
Then lordship could have it on the first week of December. The 7th for the 8th.
Maybe part lordship.
7th for the 8th. Or
Just think about how you can mitigate this. Instead of taking an adversarial view, accept what legal right has already established, what is not, and how we can mitigate it. And we are more concerned with the age of this person. I don't want to burden the state that we appoint a teacher at a time when she is almost nearing 60. If I take this view, difficulty will be once a legal injury had been caused,
the compensation part.
you have to be compensated. That compensation may be much more higher.
I think what has fallen from lordship that if we can take it to be a deemed.
But if
appointment for the-
judicially we can provide that this is a deemed appointment, then
Nominally we
what will
calculate
remain will be what pension otherwise the person would have got. And these are matters of process of 1999 and 2001. So old pension, not even this after the post 2005. Pay the minimum of the pension and close this matter.
There are provisions that can be resorted to. I can point it out to them.
And we'll put it to be not to be a precedent, only in the peculiar facts of this case.
Then
Hmm. Firstly, we'll enable you for pension by a judicial pronouncement of deemed appointment to have been done notionally when the others were appointed. And close the chapter. What kind of a health this lady is maintaining? Very robust or sickly kind of a person? Huh?
Very
Robust.
small, his condition is not good. Whatever maybe
Then you don't have to pay pension also very long time.
lordship, maybe 5 years. Nowadays, they.
So you have predicted her life
No,
5 years.
lordship, with all fairness, with all respect, lordship, whatever lordship.
So
with all
here,
fairness,
Mr. K. Mudimla sanctions 5 years of life for this man.
lordship, nowadays, lordship, what I feel myself, nowadays, lordship.
Otherwise, how do you mitigate the situation? Just tell me.
That she had a right, my lord.
It
I standing
appears.
here, I cannot deny
It
that she had a
appears.
right.
And I analyzed it, told you also
Yeah.
what remains and what goes. But frankly speaking, at this stage, I don't want mandamus for appointment.
Lordship, I leave it to lordship with all respect, but proposed lordship, but
And
my landed pet is also.
we invoke the principle of equity that if pension is paid, it will mitigate.
Lordship, with all fairness and submitting lordship, whatever something, if she will get, at least she will feel lordship that in her life something.
If she is deemed to be appointed with the others, 2001 is the letter.
No, notional that.
No,
You don't get any benefit, no salary.
Then, my lord, she would, 20 years of service should be completed by 2021. Without without pertaining to the state with trying to extract work from her.
Sorry.
My lord, that 20 years.
We'll also provide pension at the bottom of the scale.
That is what I was going to say. 2001, if we take it to be notionally appointed, 2021, 20 years of service completed. Even if she's taken to have retired and now she'll be entitled to a pension only. Perhaps then
That is what I am saying you.
because 57,
Pension and not also at a very, very high.
57, if we go for her appointment, 58 now, 59, maybe 1 year of service. If that service is.
No. We don't want to provide for that. We want to provide on the day when she would have retired, from that day pay the pension.
Then in the interim, my lord.
Interim. Nothing to be paid.
That-
And if you don't survive for 2 years, you are not getting anything.
Lordship, I did it.
So you modify your prediction of 5 years to something longer lifetime.
All right. I leave it.
We're just trying to balance the equity, nothing else.
6 for the 7, 7 for 8. If it is convenient.
Sorry? Sorry, Jerry.
I'm obliged.
List again for further hearing of this on the issue as to in what manner the grievances of the petitioner can be mitigated to the extent that prima facie it appears that the petitioner had a legal right to be appointed as per the communication available at page 99 of the writ petition. Whereas, on the other hand, with the passage of time, she is presently aged, nearing 60 years. That is the date of retirement. Other way of looking at this compensation in public law.
The pension will be a better.
That will be a bigger burden and lot of complication unnecessary.
And therefore, one permission, so the lower court records are here because it has been tagged. And the department has written a sentence, title suit number so and so was dismissed for default against the petition. I need a certified copy or a record from that copy.
No, no, we already verified it
It has been verified, no?
on the last day, but a decree includes her name.
I.
Ah.
it-
So,
Permits if I'm. if I
so
have a copy, a
under the
certified
civil
copy.
law, when there is a conflict between the decree and the judgment, the decree holds the field.
Therefore, if I'm permitted to take a copy, my lord, if I can show them that the decree contains the name, you need to go ahead. For that.
Yes, definitely.
Certified copy like that.
Item 40.
Mr. Mojumdar, we had thought it from both sides
She had a right.
to find out a way out.
My reading of the file says she had a right.
Mhm. And moment we recognize that she is entitled to compensation, if not anything else. Instead of getting that burden, I think the other burden will be lesser. And she'll be more protected also.
Yes.
At least her old age, she can spend a happy old age now.
Lordship. It will also be unique that I did not serve when I got a.
Sorry.
It will be unique, my lord. I got a. I didn't serve when I got a. Because we have a lot of cases saying I served and I am without pension. It will be one of
Mr.
the unique
Mojumdar, yesterday one submission was made. One person was suspended, one writ petition. The person was also terminated, another writ petition. Okay. For some reason, we stayed the termination. The counsel for the school authorities makes a statement that the petitioner is coming to the school every day, taunting all other teachers that you all are working and getting money and I am not working and getting any money. So sometimes people get money without doing anything also. If the balance equation of the law in the factual position is that.
Since there was a stay on the termination, one of the matters, my lord.
No, so there is no stay on the suspension.
Yeah.
Two writ petition. Suspended writ, terminated another writ. Termination was stayed. That means the suspension is revived.
In one
So
of the
person coming to the school and telling everyone, I'm in a better position now, not working and getting any money. Just next item, Mr. Islam. 4 weeks time granted on the prayer of Mr. Ganesh Pegul and Council for Elementary for filing affidavit in opposition. Sorry.
41.
My lord, I have filed one IA, my lord.
IA for what?
Yes, for vacating the order.
IA 2883 for vacating the interim order.
Yes, my lord. Then he filed.
Third MSKDB applicant interim order stands vacated.
Because they have filed affidavit in favor.
Over.
After you file reply, Lord.
Then again, he wants to file.
No,
reply.
no, it's not today for the first time, Lord.
No, government has filed one
Yes,
affidavit.
government
of
has
course.
filed with.
He wants to reply. Then it may be given.
Government is with you, but he is the other side with petitioner.
Yes, my lord.
So it is he who will
Yes,
give
my
the
lord.
reply.
It always.
At least 7 days may be allowed.
7 days granted to the land council for the writ petitioner
I
to
know.
file their objection to IA 2883/2023. List again on.
42 and
We can't
43.
give you 2 weeks. 223 will be applicable. And the order of the court, I can give it a benefit of 223.
In time you are at
7.
apply.
7.
Mr. Sharma?
These are two matters, lots of interconnected matters. Item number 42. So what has happened here is, Lordship is taking up 2976.
297.
Yes. So what has happened here is, the petitioner was
No,
working.
today what is to be done? Are you
This is
hearing?
regarding a termination,
No, are you hearing today?
if possible, because he is under termination now.
Yes, respondents, is it
And
possible?
it is basically, there's a judgment.
Mr. Sharma,
Yes.
if you are hearing, I am ready to hear you to
Yes,
the
yes, yes,
complete extent.
Yes.
If you are not hearing, let us
Yes.
not begin. Yes, who appears for respondents? PK Bora, Standing Council Education. Fixed for 3 weeks time to file affidavit, last order. So you, Sharma, should we start the hearing?
Actually,
You can't expect us to migrate to the other court and hear it there. Definitely, the learned counsel has to come here. Time being.
44,
Next,
Okay.
my lord, this is for my lord, what happened? Page number 48, I take a look directly, my lord. The inspector was forwarded.
The issue raised by my learned friend is regarding questioning my B.Ed certificate that I have obtained from Sati Bhushan University, my lord. My lord, a coordinate bench has already delivered a judgment upholding that Sati Bhushan's degree, and that has been appealed before the division bench. And
Which
it
is
now-
pending.
My lord, still pending the issue, my lord. Now my learned friend is saying that I am not going to press that B.Ed degree.
Who is not going to press?
My learned friend,
Whose BEd degree is from Sosi Bhushan?
my B.Ed degree has been.
So how
questioned.
he cannot press upon your degree?
No, he is saying, my lord, that in this petition, though he pleaded, now he do not want to press it.
Press that issue. You withdraw the petition.
No, my issue is, my lord, two aspects are there, my lord. My case is in the page.
One issue you do not
I
press.
do not like to press.
You want to press the second issue.
Second issue, my lord.
File an affidavit, will they delete one of the issues?
My lord. But page 48,
This cannot go on oral thing. So today I'll do something, tomorrow I'll go in appeal and say the court did not decide this issue. Nothing doing. No,
disposable, my lord.
nothing doing. File affidavit, will formally close one of the issues if you want. Nothing on oral.
It was, my lord, the admission for consideration of interim order was there, my lord, it was not considered.
Today you want interim order.
Interim order, the
File an
direction in the first order, while issuing notice, my lord, the consideration of interim order, my lord.
Where is that order? Order dated
16, 6, I think, my lord.
16?
6 June, in June, there was order, first order.
It's nothing is stated that interim order will consider next day.
On returnable date, my lord.
No. On returnable date, authorities will apprise the court whether degree of the petitioner is a valid degree. That's all. Nothing to do with interim order.
Petitioner is going to retire otherwise.
File I.
Lord, I am going to retire before him, my lord, in the month of December. He is going to retire, my lord, in March.
You are holding the post
I am in charge.
illegally.
till December.
My lord.
From January to March, you hold the post. Why are you fighting?
Your ultimate demand is before
Mr.
the.
Purokayastha, in your fight, none of you will hold the post. Somebody else will come in.
My lord.
What happened, my lord, while sending this information, my lord, wrongly sent, my lord.
Mr. Purokayastha, going by the statement of Mr. Bhuya, it appears neither you will get nor he will get. So better take turns. After December, let him get it, and from January to March, you get it. After that, somebody else will come in.
Your lordship dispose of in the.
Otherwise, if I decide this matter, somebody else will come in right now.
Your lordship dispose, my lord, with the.
This was in what terms?
After December, after his retirement, I mean. Because now I'm senior to him otherwise, right?
What do you mean by the word dispose? Dispose requires an adjudication. What will I adjudicate? That Mr. Bhuya is entitled to December, Mr. Purokayastha is entitled up to March. This is my decision. Can it be a decision? Then best course, both of you adjourn it till April. And who appears for the department? We need not decide this matter. Let Mr. Bhuya's client continue till December, he'll retire. You both are having issues whether they're qualified or not. From January to March, allow him to be the in-charge principal. He will also retire in March. From April, you make a regular selection of a regular principal. Possibly. But if I decide, it will go against you as well as him, both. None of you will get.
What happened, my lord? They have.
Okay, argue. Argue. Argue, yes. Are you ready, everyone? Let us hear him. Yes, Mr. Burrow, to start.
My lord, my case is that, my lord.
Where is your B.Ed degree?
My PhD degree is there.
Which page?
What happened, my lord? My page number 49.
Will not happen. Where is your B.Ed degree? Which page?
PhD degree page 31, my lord.
31.
My PhD degree, there is no question, my lord. This is on deputation. And my MA degree is also.
Just a minute. MA degree. Where is your MA degree?
MA degree, my lord. MA certificate.
Page number
Page 35, my lord.
35. Yes, state, why do you feel this degree is a little clouded? Page 35.
While sending the proposal, while sending the proposal,
Just
my
a
lord,
minute.
at page 49, I have shown that I'm not having the qualification.
Is this an acceptable degree in law? Page 35. Is it a valid degree? Valid. Then why don't you make him the principal? Never been recognized. Recognized by whom? Which authority? Why? Uh,
But it has not been reflected in
service book.
Seniority.
You correct it. Let him file an application to the departmental authority, placing his degree. You examine whether acceptable or not and do the needful.
Yes.
And we are not interfering with anything.
That I said.
Only thing, why he.
How can you oppose it?
No, I am not opposing.
You have no legal right to any locus to oppose. He says that I have a degree, department is not taking note of my degree. That is his violation of his right. You are only a consequential beneficiary of his right not being taken note of. You cannot object any locus to oppose him to that. Third, Mr. B. Procastel and counsel for the petitioner also heard. Mr. B. Kaushik and counsel for the Secondary Education Department of the Government of Assam. Mr. A. Alam for the respondents in the NCTE. Mr. A.R. Bhuya for respondent number 5, Habibur Rahman Majumdar, Assam University. MS so-and-so for the respondent 6, the Assam University. The petitioner who is a teacher in the what school? What kind of teacher?
Public higher secondary school, Hailakandi.
Who is a teacher in the
Graduate teacher in the public higher.
graduate teacher in the public higher secondary school
Hailakandi.
at Hailakandi had acquired his Master of Arts in History degree as per the certificate dated 15/11/2022 issued by the Indira Gandhi National Open University and his Bachelor of Education degree from the Assam University as per the certificate dated 13/12/2022. Indira Gandhi, which is available as Annexure 5A, page 35, or EFON, Annexure 3B, page 31. There is an issue to the extent that the respondent authorities, while determining the qualification, while reading into the qualification of the petitioner, had ignored the Master of Arts in History degree obtained from the Indira Gandhi National Open University. Consequence thereof, the petitioner is deemed to be ineligible for to hold the post of principal of the school on an in-charge basis. The consequential beneficiary of that is the respondent number 6, Habibur Rahman, who is allowed to be the in-charge principal. The petitioner also states that by the representation dated, he had brought it on record as well as for the notice of the respondent that he had also acquired the Master of Arts in History degree from the Indira Gandhi Open University. In view of the factual situation as indicated above, the respondents in the Secondary Education Department of Government of Assam is directed to give a consideration to the representation of the petitioner dated so-and-so, and also take note that it is the claim of the petitioner that he has also acquired the Master of Arts degree in History as per the certificate dated so-and-so issued by the Indira Gandhi National Open University. Upon doing the needful, the consequential benefit that a petitioner may be entitled may also be looked into. The requirement of dealing with the representation be done within a period of 5 weeks from today. 5 weeks from the date of receipt of the certified copy.
Representation date matter 10/11/2020.
10/11/2020.
2020. Apply.
It's so relative.
Sorry.
It's so relative today. Apply.
You are not relieved.
Oh, I am also.
You also escaped the
I am also relieved.
consequences.
Apply. Item 45.
Yes, Madam Chaudhary.
My lord, this matter it is to compassionate appointment matter.
DLC,
My lord, rejected without assigning any
Page
reason,
number?
my lord. At page 25, my lord.
serial number. Lokhi Begum.
Page 25. Okay, 35, serial number 35.
Third, Mr. B. Kaushik for the respondents in the Secondary Education Department. None appears for the Deputy Commissioner. Is anybody there, government? Where is he gone? None appears for the Deputy Commissioner Karimganj. The husband of the petitioner, Abdul Basit Chaudhary, who was an assistant teacher of number 2 Korno Madhu LP School in the Karimganj district, died in harness on 2011-2004. And on his death, an application for compassionate appointment was made on 11/3/2005, which was placed before the DLC of Karimganj district in its meeting held on. What is the date?
My lord, DLC date, my lord, 37/2009.
Oh, 37. You can read it.
My lord,
Can you read the date?
yes, my lord.
Why I cannot read it?
My lord, my lord, saying from the synopsis, my lord.
No, no, if you can read the date from page 21, why I cannot read it? Madam Chaudhary, take a look at page 21, which I am
My lord,
reading.
signature is there, my lord.
Okay. Over date to put it.
Signature is there, my lord, at the
Hmm.
top, my lord, left side.
Look at the top.
Date is there.
Look at the top. What is
At
there?
the top, my lord, my.
Nothing is there. Hmm. That is not the date. That may be a initial put by anybody at any given point of time. The date ought to have been here. কি বলবো, date to forgive. Perusal of the resolution of the DLC, dated so and so, makes it discernible that no reason had been given as to why the application of the petitioner for compassionate appointment was rejected. The law laid down by this court in what is the other one? One Faziran and the other one? And Achut Ranjan Das requires the DLC to make
My
an
lord, date is at the last page. my
make
lord.
an
Page 26.
make an inter-se financial comparison of the applicants and thereafter to make recommendation in favor of such candidate who may be comparatively financially worse off. As no reason is forthcoming for the rejection, it is difficult for the court to examine as to whether the aforesaid exercise was undertaken while rejecting the application of petitioner. For the reasons as stated above, the rejection by the DLC in its resolution dated so and so set aside, remanded back to the DLC for a fresh consideration as per law to be placed before the next available DLC.
My lord, date is at the last page, my lord, page 26. 37/2009.
Then why did you annex that page 21 in the given manner?
Not having.
Where the photostat copy is blank in respect of the space where the date ought to have been there. Next one, yes.
46 for orders.
Vicky, it agorphin.
My lord,
Yes,
my
Mr.
lord,
Decker.
my lord, infractors, my lord.
Infractious.
The private respondent, my lord, respondent number 5, he joined other school, my lord, and 6 died, my lord. So nothing remains except my lord, regular process for election.
And the petitioner?
But he's holding the in charge, my lord. The government has to issue again regular.
What did you assail?
My lord, here we have challenged their selection, my lord.
Mr. P.K. Dekal and counsel for the petitioner states that the selection of the respondents number 6 and 7 5 and 6 for the post of
Principal of Satrasar Vidyapit,
principal of Satrasar
HS Vidyapit.
HS Vidyapit was assailed in this writ petition in a circumstance where the petitioner is continuing as the in-charge principal of the school. It is stated that during the pendency of the writ petition, both the respondent, both died.
Respondent 5 joined other school.
The respondent number 5 had joined some other school as principal, and respondent number 6 had died in between, and therefore no adjudication required. In view of such statement, writ petition closed. Interim order passed earlier stands vacated. It now to appear for the this next item.
Item 47.
In this matter, you will also speak to. .
This is factual aspects we are not very clear till now.
Yes, my lord.
All that we understood, I think Mr. Sharma's client in the selection process were on merit higher. Your client or Burma's client? Somewhere like this, somebody was higher, somebody lower. I don't know. The submissions made till now by Mr. MP Sharma, I remember only that. That his clients were supposed to be a little higher on merit. Madam Burman's clients were supposed to be a little lower on merit. But because of the infrastructure that was available,
Exactly.
you could not appoint all the selected candidates. Madam Burman's clients were appointed at a prior point of time earlier. Mr. Sharma's clients were appointed a little later. Then Mr. Sharma's client make a claim that by virtue of my merit position in the same selection process, I am entitled to seniority.
Yes.
That was granted.
Yes.
Okay. Now, Madam Burman's client challenges reversion of his seniority on the ground that, as per the prevailing rules, he refers to a particular provision,
Yes.
that it will be on the basis of the date of appointment or date of joining and nothing else. Her claim is, as per date of appointment, I am prior. Now, how do you solve this issue?
Look, I have received some instructions recently, Milo. But I think there is requirement of filing an affidavit in this matter. From High Court side, no affidavit has been
You want
filed.
to
as
file?
of now. So,
Let the affidavit come, we can decide.
yes.
I think we have understood your case.
Yes, yes. That is the case. Lord, yes.
Mr. H.K. Das, legal counsel appearing for the respondents in the High Court, prays for an adjournment to file an affidavit on the issues raised in this writ petition.
Yes.
Pray aloud this after
3 weeks.
3 weeks.
Not date. Date may be.
Did you date like 3 weeks?
13.
Tuesday or so that matter can be disposed of. Long pending case.
December.
15 December.
48.
Deep you. No, take it. As per occasional I have asked to submit a amended cost title regarding the petition of name of the respondent. I have submitted an official statement.
Submitted what?
Amended cost title of.
Amalgamated writ petition.
No, my lord, amended cost title, deleting the name of the respondent number.
Amended cause title.
As for the office note, I have submitted it. So, my lord,
Pursuant to the court's order dated 1810. Has submitted amended 1810. Eighteen ten. Okay, you want to delete the respondent number?
Director, I was asked to file a contract of the statement.
We have not asked you to file any amended cause title.
I was on a telephonic communication.
No, this will lead to complication. Amended cause title means you have to file for amendment of the writ petition. Otherwise, we cannot.
In the office note, I have asked.
So therefore, we deliberately not required to file any amended cause title, just required the registry to delete respondent number 7.
And I was asked, that's why I.
Complication করেছে শুন বই ফলে
I'm intending to file in a.
order to assail number 7 দরকার নাই to delete দিয়ে delete করে ফেলে fill করে registration deleted submit amended course moment it is amended you have to file amended petition all kind of complication. We had taken note of our earlier order of 1810-2023, wherein it was provided that the area of respondent number 7 be deleted. Further, Registry has put up an office note of 21/11/2023 requiring the petitioner to submit an amended cause title. Amended cause title is a subject matter pursuant to an amendment being allowed to a writ petition. Whereas the judicial order of 18/10/2023 is to strike out the respondent number 7. Registry to do the needful to strike out the respondent 7 from the area of respondents without insisting on any amended cause title.
49.
Obliged.
And also provide the information in the CIS system. Yes, madam.
Yeah, please, Lordship, in this matter, we have not furnished copies upon the respondent authorities. We have not furnished copies upon the respondent authorities, so we need 3 days time to serve them copies.
Why? It's stated by your name. Your name.
You, Nanda.
You, Nanda, that the extra copies of the writ petition had not been furnished upon the respondents. Petitioner may do the needful.
Much over.
50 and 51 for hearing.
That same matter. What is to be done? Mr. RKD Chaudhary appeared also, I think, and you also appearing. What to do? But Mr. Padgiri, have you considered that if I pass the order, your client will be in more difficulty? The writ petition will be allowed in your favor, but the consequence is you'll be in far more difficulty. Which one do you want? And he says he wants the order. Now only your service is gone, dismissed. If I allow your petition, you'll also be convicted and you'll be inside. You have to go to jail also. So you want to writ petition be closed, being happy with your service matter? Or you want the writ petition to be allowed, subject to the risk that now you'll be convicted also. And your third option is there. If you modify your argument that force court and general force court, you abandon that argument and you argue on the merit that this decision in the existing materials could not have been taken. You can argue that. You better don't urge upon the first ground. You'll be in trouble. Then they'll be very happy to do it.
I informed my client that he will ready to.
He would like to go to prison.
Yes, not so, madam. He quoted the law, madam.
That is the law we are pointing out. You'll be in trouble, I'm telling you. You'll also be convicted because that's a serious criminal offense, what you have done. And one way you can save yourself is you don't urge upon that issue. You argue on the merit that upon this material on record, this order could not have been passed, or it is. That will hear you. Then you may reduce the sentence from dismissal to something different. Apply your logical mind and ask your client also to apply his logical mind. Everything is not just forcefully pushing it through. Legal issue we have raised, we are interested. And there's a likelihood of it being decided in your favor. But moment I do that, you are at the peril of being convicted now. Convicted and sentenced, and this will be quite a good sentence. Unauthorized use of arms in this manner, you may get up to about 7 years of imprisonment.
Another proceeding if madam initiated.
Another proceeding, all the materials that is already available will be retained, mind you. and the materials already on record is not much in your favor, that another proceeding is the likelihood of being exonerated of the whole charge, that likelihood is almost negligible. He must be thinking in one year's disorder pass, one more proceeding, I'll again with renewed vigor, I'll defend myself. But whatever the materials already on record, you cannot obliterate it. That is likely to go almost against you. Personally appear. Why should you entertain this man personally? We don't have any business. So we are not here for counseling litigants. We are here for deciding matters. Only thing our conscience says that we should also indicate to you about the consequences. So we are doing it. That's all. This is neither a mediation proceeding nor a counseling proceeding of anybody. But mind you, when you were proceeding in a road which is directly leading to a river, without having any bridge, you are bound to fall in the river. And you don't need some other extraterrestrial agencies to know whether you will fall in the river or not. Yes, Madam Devi, what to do? The legal issue raised, our prima facie view is against you.
Proceeding in the fourth court is a judicial proceeding, Lordship, as per rule one.
No, this man will be in trouble if you proceed against
Yes,
him one more time. I'm quite sure of it. Because the force court will have both the powers. It will have the power of a criminal court plus the power of a disciplinary court. And with the charges, you are most likely that punishment of dismissal from service in this service matter will be retained. But once they invoke the power of the criminal court, you will be convicted and sentenced. It's good thing they have missed it out and you are means there is a saying, Nijor Bhorit Nija Kothar Mare. Why are you heading for that? Adjourn, we will listen to it. Again, no, Mr. Didio, think over.
Okay.
And your client, maybe he is advised or he is thinking that once there is a de novo proceeding, I may escape from the entire thing. But with the existing material on record, most unlikely.
Item 52 for motion.
It's regarding the law examination. The university stand is that in exceptional category, but their difficulty is that there is no such provision in the
Where are the rules of the university?
there is
No
such provision.
No, I know. Is there any inherent power? Not specific provision, any inherent power? Like those 151 in CPC, 482 CRPC. In general, inherent power to take note of some, because what he says is a little of concern also.
The rate also admits.
It's a little concern to allow this person. And if we don't allow, we'll be interfering with the right to education of this lady.
Court of equity.
We exercise our power.
Internal clauses act. Section 18.
Some general clauses একদম কি আছে? You check up your rules somewhere whether the university has an inherent power to remove any difficulties that may be because of the implementation of the rules. If it is there, we can ask you to take note of them. That is one way out. But frankly speaking, next week, Monday, Tuesday. Frankly speaking, I don't want this lady to be exposed to the possible circumstance what she will face if I dismiss the petition.
Okay. 53.
Yes, Mr. Loskar. Yes, Mr. Loskar.
Against the amalgamation, the LP.
Amalgamation.
Against another LP school, my lord. Here in this case, my lord, there is no LP school within radius of 1.5 kilometers. And apart from this, my lord, there is no,
Where is those guidelines and
my lord,
conditions?
page 18.
18.
1. Clause 13, my. If two or married.
Clause?
13, my.
Page, clause 13.
Page 18, clause 13. 1.
Clause
1.
page 18, clause 13. Okay. If the student does not exceed 100 and two schools are located within a radius of 1 kilometer, there may be a merger. And now,
My school having 33 students. And apart from this, my lord, road connection,
so now your school has
33.
33. So it does not exceed 100. They can merge it.
No, there is no other school within 1.5.
Hmm.
And apart from this, my lord, the connecting to the school with which my school is being merged, my lord, the students will require to.
No. If two or more LP schools are located within 1 kilometer,
Within one.
he says possibly it is not within 1 kilometer. It is more than 1 kilometer.
We'll have to take it.
Timing, say you file your affidavit, we'll vacate it. Because these are balance of convenience is always in favor of stay, because once you do the merger
Yes, that's
and tomorrow I find it illegal, you cannot demerge them again.
Well.
Let Mr. G. Loskar B. Kaushik, Elementary Education Department. Notice 6 weeks, extra copies 3 days. The petitioner school, namely Niz Vernerpur Nalarpar LP School in the Hailakandi district, is sought to be merged by the order impugned dated
13/10/20.
13/10/20 with another LP school. The petitioner, by referring to clause 13 of the office memorandum dated 30/8/2021, assails the merger on the ground that in order to effect a merger, there is a requirement that the number of students of the schools should not exceed 100. And secondly, it must be located within a radius of 1 kilometer. In the instant case, although the petitioner school has less than 100 students, which is stated to be about 36, but the distance between the petitioner school and the other school with which it is sought to be merged is more than 1 kilometer. Accordingly, a plea of merger being effected in violation of clause 13 has been raised. your primary bands are convenient till until further orders, the merger of petition school with so-and-so LP school shall remain stay. What is the other school?
Other school, my lord, Dhubri Tal LP.
Naam to likhi loga, huh?
Like there is also an appeal they have filed, my lord, that.
Pendency of the petition as well as the interim order shall not be a bar on the part of respondent to give a consideration to the appeal that is so-and-so filed by the petitioner. And in the event a final order is passed in the appeal, the same shall have preference over the interim order passed today.
15/11/2020.
And the writ petition would be deemed to have become infructuous.
My lord, road connectivity.
All these aspects here raised in the.
We are staying for a different reason, not on road. Road connectivity, I'll have to go for an inquiry whether there is road or not.
54 to 56.
Your lordship. My lord, in this case, my lord, petitioners were working.
I know, BTC.
Yes,
Hmm.
BTC, my lord.
Drop teacher.
Drop.
They have undertaken some process. What
Yes.
happened to it?
That they have admitted in affidavit also, they have approved our post. They have admitted.
Some of them have been. Some even are yet to be as per last court or lordship, I have not received the status of the rest of the pending.
It is stated by Mr. B. Choril and counsel for respondents in the BTC that some of the petitioners have been given the benefit
No
of.
benefit, not the present petitioner. There are 134 candidates are there.
No, he said that somebody is.
No, my lord, 134 candidates were there, my lord, for gate 4 and 15 for gate 3. Half of the out of that, my lord, 90 were regularized and 3 for gate 3 were regularized. Left, there are gate 4, 12 gate 4 were left, and gate 4 78 are left out, and gate
Madam
3
Devi,
were
at the end of the day, I can't remember so many figures. It's very difficult for me.
And they have
Now, what is to be done? All are not given the benefit.
Yes, my lord.
Some of the petitioners are given, some not.
Same list.
That's what I am trying to say.
Yes.
But you have objected to it.
Lordship is disposable of my lord, because affidavit also your lordship on
Not,
basis of
not with those half-baked orders. That have been granted the benefit that of regularization
Yes.
that they have claimed for, while in respect of some of the other petitioners, it is still under consideration. But however, there is an affidavit filed by the BTC which states that.
Lordship para 17.
What does it say?
That deponent have complied with the direction of 325.
Had they made a statement that will give favorable consideration to the balanced people?
Yes.
Where is that statement?
20 also, Lordship. A proposal of prior approval against vacant post.
So that is under
20 was
process.
made, and BTC authority bearing dated 91 of post. Here is also Lordship in.
List on so-and-so for an updated information. And also a BTC authorities to make a specific statement before the court whether they want to give the benefit of regulation to the other petitioners or they have any objection to such. Based on the statement, we'll close it next day. List on so.
Timing item 8.
Means, Mr. Chaudhary, we will not allow you to go on extending time. Now we will bind you, make a definite statement whether yes or no.
Yes.
If yes, we'll conclude it. If no, we'll have to hear both sides.
Yes.
Is your lordship. Last page of my petition, lordship, is
Hmm?
the impugned. Last page of my petition is the impugned order, by which details is rejected. My
Compassionate appointment.
Yes, Lord.
Page number?
Minor lordship. Last
Khadim.
page.
Mr. Khadim will be applicable. Heard MS
Yes, come.
as Kanugo, like other petitioner, also heard Mr. P. Saikia, learned additional junior advocate for this Deputy Commissioner. Hailakandi, as well as the Chief Secretary to the Government of Assam. Oh, no, Chief Secretary, nahi. Hailakandi and Mr. Ganesh Pegul and Council for Responding Elementary Education Department, the father of the petitioner, Chakrapani Paul, who was the head teacher of 97 number Dinonath Dinonathpur LP School in the Hailakandi district, died in harness on 10/8/2002, and on his death, the petitioner made an application for compassionate appointment on, what is the date of?
2017.
On 1/1/2017. The said application, when placed before the DLC in its meeting of 5/10/2021, was rejected on the ground that the deceased died. That at the time of submission of the application, the age of the petitioner was 17 years, 11 months, 6 days. And whereas the deceased employee died on 10/8/2002. In other words, two reasons are discernible as to why the application was rejected. The first being that on the date of application, she was 17 years, 11 months, 6 days, that is, had not yet attained majority. And secondly, there is a wide gap between the date of the deceased employee and the date of the application of petitioner. Regarding the first reason, we take note that as per the judgment rendered by the Honorable Supreme Court in paragraph 35 of the judgment in N.C. Santosh versus so-and-so, report in so-and-so, the norms prevailing on the date of consideration is to be taken note of, and admittedly on the date of consideration, the petitioner had attained majority, and therefore it could not have been rejected on the ground that on the date when the application was made, she had not attained majority. On the reason of second reason of rejection, that there is a wide gap between the date of the death of the deceased and the date of the application, we take note that on the date when the deceased died, the petition was admittedly a minor, and in such circumstance would be governed by the proposition laid down by the Honorable Supreme Court in Khadim, report in so-and-so. Accordingly, matter remanded back to the DLC for a fresh consideration by taking note of the entitlement of petitioner as per the law laid down by the Honorable Supreme Court in Khadim, and pass a reasoned order as per its entitlement.
Para 19.
90.
31/32.
It is there.
My lord, in this matter, petitioner may be moved.
Sorry.
Here, my lord, gradation as per best gradation list, and he is come under the serial number 2, man.
So will you promote him or will you not promote him? No.
No, he can be actually.
Sure.
Yes, ma'am.
No, do one thing. If she can be accommodated, file a short affidavit. We'll incorporate the paragraph in the affidavit and dispose it off. I will not decide the matter on its merit. So later on, you are binding with your agreement. Upon obtaining instruction, Mr. U. Sharma, Land Council for the Education Department, had stated that presently the petitioner is at serial number 2 of the gradation list. And it being so, he or she she can be accommodated for promotion to the next higher post of UDA.
Senior.
Place for senior assistant against the vacant posts which are existing as on date.
In the office of the inspector.
In the office of the inspector school. The said statement be made in the form of an affidavit, a short affidavit, incorporating only the statement and not a complete affidavit in opposition. Affidavit be filed within 1 week, list on so-and-so for further consideration.
4 December.
Right. Mr. BP Bora appears for 5, 6, and 7.
42 and
You
43.
have to show your client.
Sometime required for filing affidavit.
Sorry,
Sometime required.
some time required for what?
for filing a affidavit.
Affidavit.
I'm on the termination. The order itself says that it could not have been done in the manner it has been thought to be done. What has happened herein was,
We'll file it within a week. We'll hear you.
Yes.
Mr. Ganesh Pegul and counsel appearing for the elementary states that the department would like to file an affidavit. On the other hand, Mr. A. Sharma and counsel petitioner states that the petitioner is under termination, which prima facie, according to the learned counsel, appears to be unsustainable in law. Balancing both these submissions, the affidavit be filed within a week, list on so and so for further consideration. Take a fixed date, file it before that.
Obliged.